Oh. Ah oui, Baptiste, voilà. C'est dont j'avais besoin. So, good afternoon, everyone. Welcome to our last lecture on the law and economics of merger control. For this session, we have the honor to have Chris Cook, who is a partner at Clearly Gottlieb. His practices focus on international competition and antitrust law. Chris has extensive experience representing both transacting and opposing parties in merger and joint venture before the European Commission and various national antitrust regulators in and beyond Europe. We also have the honor to guest Michele Piergiovanni, who is a member of cabinet of the Executive Vice President Margaret Vestager at the European Commission. Michele is the head of unit of DG Competition of the European Commission, dealing with merger in the IT, telecom, and other media sectors, and much more. Michele, I will let you introduce yourself as well, better than I do. So finally, at the end of the session, for a short 1-hour Q&A session, Nick will join us together with Chris and Michele to discuss merger control. And please do not hesitate to open your microphone and ask questions. We will try to do 2 breaks. And Chris and Michele, the floor is yours. Thank you very much.
Thank you, Valerie. So nice to see everybody. It's fairly rare these days to get out in public almost, or in a group session. So yeah, as Valerie said, I'm a partner in the competition practice at Cleary Gottlieb here in Brussels. So the kind of stuff that we're going to talk about today is what I kind of do every day for my job. We'll have 3 topics today that we're going to cover. First is procedure, second is remedies, and third is judicial review. We'll spend the most time on procedure, which might sound like probably it is the least academic part of the course, maybe not the most suited to final exam questions and that sort of thing. But it's interesting if you would like to work at a law firm or do mergers at the European Commission, because this stuff is the stuff that you do every day. You're not necessarily thinking about academic questions on merger control from morning till evening in your day-to-day work, but you are dealing with the process a lot. So I remember from my law school days when I started work ages and ages and ages ago, thinking, wow, I sort of knew the theory about antitrust and merger control, but I really had almost no clue what people actually did on a day-to-day basis. And so that's going to be more the first, say, 2/3 of today is really about what we do. Lots of people online, and plus the good hardy folks who've come into the room today to not leave me all by myself, which is great. We will we're very much welcoming questions. We might call on people, ask really hard questions, and Michele will do his best to answer them. So Michele, do you want to say anything before we kick off?
No, first I want to apologize with the students in the classroom. I was supposed to be there, but I've been coughing and sneezing now for a few hours, so I thought I might as well stay home and not spread further the virus then. Otherwise, so sorry about that, but I'll try to do my best by being online. I think, Chris, I'll let you take the lead and try to interrupt you once in a while to say something, but I guess I leave you to kick it off.
Please interrupt as often as possible, because people certainly do not want to hear me for 3 hours. Okay, let's kick off. So procedure. What we're going to talk about today is, well, pretty much the nuts and bolts of doing merger cases before the European Commission. So you've got the EU merger regulation, as you very well know, and the implementing regulation that contain all the rules on procedure on how do you notify transactions and what the procedure that the Commission follows in assessing them. And the Commission has some best practices guidelines too that talk a little bit more about the kind of day-to-day, how we lawyers are expected to behave if we want to have good cooperative relations with the case team. The list of topics we're going to talk about today is kind of, well, beginning to end of a merger review process. So pre-notification dialogue, that's a big part of the practice and the time that a case actually takes to do. We'll talk a little bit about mandatory closing notification and the standstill obligation, about the Form CO, which is the document that you have to write and give the commission containing the information about the transaction. Talk a little bit about the commission's powers of investigation. Maybe Michele has some words on that, and the role of national competition authorities in the EU process. And we'll go through kind of the mechanics of how commission merger investigations work. As you probably know, there's a phase 1 and then there's phase 2 in cases that raise potential issues. And we'll talk about really the steps that each of those processes takes. And then a little bit on the rights of third parties, which we'll come back again to in the judicial review section. Just a quick word on the best practices guidelines. This is a document that the Commission published like 15 years ago. And what it does is, it's a pretty long document, and it says kind of what the case team's expectations are in terms of day-to-day, how they want merging parties and their lawyers to present transactions to them. We always try to keep a really constructive, cooperative environment with the case teams that are reviewing that, and then 99 out of 100 cases that is successful. Really, disagreements between lawyers and case teams are quite rare, and most often everyone is really pulling toward the same goal, which is reviewing transactions, most of which are non-problematic, kind of as efficiently as possible. And then there's also the rules are basically to increase the transparency to the parties as to what the commission is doing internally. Michele might have some secrets to tell us about that a little later on. So the rules contain guidance on how the pre-notification process works, what the commission does in terms of its fact-finding, its investigation, through information requests or through talking with third parties like customers and competitors of the merging parties, and then some specific processes or steps in the procedure that happen, like state of play meetings, access to the commission's case file, and the right to be heard. And we'll talk about all those later on in this section. Michele, maybe let me pause there. Anything you wanted to add about the best practices guidelines and how those play in your work?
No, I think the one thing which is important for those who approach perhaps merger control is certainly this is as Chris was saying, there is a document that governs the day-to-day relationship between us and the case team and the parties. We try to stick to them, for example, in time to revert to the parties within 5 working days whenever they start making a submission, to try to, again, not to prolong pre-notification longer than needed, and then especially when the clock starts ticking, and Chris will get to that later on when it talks about phase 1 and phase 2 processes. Their best practices set up a number of milestones in the process, which are very important and also linked to the right to be heard, which also Chris will touch upon later. So I think it is an important document. It's perhaps a bit old. I mean, it's 18 years now since the guidelines were adopted, but it's still very much current in terms of the real milestones of the process.
Great, thank you. So just a contextual slide here in how this, what happens. Most transactions do get cleared. The commission doesn't block very many deals. In fact, it's only blocked about 30 mergers in the 30 plus years that the merger regulation has been in existence. And you see there at the bottom, about 93% of transactions that are notified get cleared unconditionally. So a lot of the interest in cases that you will read and study is obviously in that 7% or even in that 0.38% of prohibition decisions. But In terms of day-to-day work, those are rare cases. 95 almost % of the deals that we work on are unconditional approvals. Sometimes they require a lot of work. They require a high proportion of the overall work we do in a year. But you probably don't hear too much about those in an academic setting.
And on our end, just to complement, we're really trying to make sure that those cases that occupy that comprise a large part of the pie chart that Chris showed are really dealt with as efficient as possible, to try to use our own resources to really focus on the 0.4, or at least on the other ones where are problematic and may require remedies, which is why we're trying to simplify the process as much as possible for those cases which are non-problematic, and really to focus the resources we have on the little small slices of the pie, which however are the more interesting and relevant cases.
Absolutely. So this slide shows all the deals all the mergers that the Commission has blocked, 30, and it's a little bit, the slide is not exactly to scale. You can see it kind of a little bit of pattern in waves, where there was a few prohibitions early on in the first decade, and then a little bit of a slowdown, then a high period, you could say, of enforcement at the Commission in the early 2000s, which soon turned out to be seen as more of a low period. There were several deals that the Commission prohibited, but then got reversed on appeal at the court, which really led to, I think, quite a reckoning in DG Comp, and probably made the Commission more conservative, really having been pretty rebuked by the court. Three merger prohibitions overturned in short order: Schneider, Legrand, Tetra Cedel, and Airtour's First Choice. Then you see quite a slowdown there in the middle of the chart, where the Commission only blocked one deal in a period of about 5 years. And then maybe the financial crisis of the 2007 to 9 period might have contributed to that too. Things start to pick back up in the early 2000s, somewhat regular, prohibition or two a year. And then kind of a more dense period again in the early part of Commissioner Vestager's tenure, coming up towards 2020. A pause during the pandemic. I don't think that was related, because the Commission has certainly been busy with mergers during the pandemic time, but no prohibitions for a couple of years, until very, very recently, like last week, the Commission blocked a merger between two large Korean shipbuilding companies, Hyundai and DSME. So that was the first prohibition decision in a couple of years. So that's the context. Now I think we're going to get into really as I say, the nuts and bolts of this kind of work, and what lawyers and the Commission officials do in their day-to-day job. So pre-notification dialogue, we mentioned this a minute ago. This is a really, really important part of the review process. You don't just fill out a notification form, submit it to the Commission, and then hear what the Commission has to say about it. The timetables under the merger regulation just don't allow for that. The Commission would get jammed up on timing too much, and I think a lot of deals that probably don't need to would end up going into phase 2 just because the Commission ran out of time and couldn't get a clearance decision formulated during the 1 month or so period of phase 1. And so the best practices guidelines go through this quite a bit, but what a major part of the practice and a major part of the overall timetable of a merger review is what we call pre-notification. And this is answering some questions like, first of all, is this a reportable transaction? Usually, if you're there, the answer is yes. Do we meet the jurisdictional thresholds? Again, usually if you're there, the answer is yes. Occasionally, there might be some issues that are not clear. And then more importantly, what does the Commission think? But does their deal look like it raises any issues? Or what information does the commission need, most importantly, to establish, to decide that a transaction doesn't raise any concerns? And that's the bulk of the pre-notification discussions. Is you submit a draft notification or a briefing paper. The commission case team that's assigned to the case reviews it, asks a bunch of questions. You answer them, probably submit another draft of the notification. And this is even in the simplest cases. You'll have that sort of process for a month, maybe a few weeks. But in some cases, pre-notification can run into many months in complicated cases. And I think there are cases when the commission has issued more than 100 information requests during pre-notification. So it can be a really massive, intense investigative period, really, for the commission. It's not just formalities like do we meet the jurisdictional thresholds? It's really the commission understanding the facts. And I don't know, Michele, I'm curious as to your thoughts about, what in a significant transaction, what's kind of the point where the case team would usually say, okay, now it's time, we're fine if you submit the notification. What level of knowledge do you feel like you need to have for that?
Yeah. And I reply to that point in a second. I think you should also, to the extent you follow merger control, I think the issue of notification is one where the commission has been criticized, and many people have written about it. And Chris, I think you're one of them to written about, again, how does this notification process impact the overall timing of a deal? Because you know that we're going to get to that, we'll have a phase 1 and phase 2 process, which may be also very lengthy. But pre-notification adds a chunk at the beginning of the even before the clock starts ticking. And so I think that there is, I think to some extent, a founded criticism of some pre-notification being too long. And as many things, probably the right way to do it is the middle one. That is to say, in easy cases, pre-notification should be swift, and the commission, I think we are trying all what we can to speed up pre-notification and to answer all the questions that Chris had, in particular on jurisdiction, as quick as possible, so that easy transaction can be notified quite quickly. Complex cases, I think are more complicated. I think often there's a lot of front-loading work. Sometimes the parties have their own also transaction timelines. I think also there can be an open discussion between the advisors of the parties and the case teams. Say, look, we have, say, 6 months of pre-notification, and we really have to file because we have to get the clock ticking, because otherwise we're not going to be able to complete on time. And normally there is understanding on the part of the case team to try to accommodate legitimate business needs from the parties to get the transaction notified and the clock ticking. So I don't think there is a magic moment in the process. I think the magic moment is also in terms of when the transaction is ripe for notification. I think is more of a discussion which takes into account, on the one hand, how forthcoming the parties are in presenting arguments, and at the same time, what are the business needs in terms of possible long stop date or need to close before a certain date. No.
Right. I should say too, although the length of pre-notification, as Michele says, sometimes is a source of frustration to merging parties. I think it's taking too long, and that the commission is asking too many questions that it really doesn't need to ask. At the same time, in many cases, merging parties really don't want to go into phase 2. It's just a more burdensome process. It's a lot longer. And so the pre-notification really might be extended perfectly fine with the merging parties, because they want to get the commission comfortable kind of before they file the formal notification and start the clock, where they've only got a month to figure things out. And so there are a lot of cases, I guess a recent one being maybe Google Fitbit, a huge merger investigation that took the best part of a year. That was a phase 1 case. So you'd had about, if it took a year, 11 months of pre-notification and a 1-month review period. So it can really go that way. And that would have not been, that would have been something that Google would have said, that's the way we want the process to work. It's not just always that the commission is taking too long. Hi, yes. question.
So one question from a lawyer's perspective. So if you plan to do a merger, do you already think about, the possibility that the commission says it's okay before you do the pre-notification dialogue, or do you do it also during the dialogue that you check on your own whether it's possible or not?
Yeah, you would certainly in a major transaction that, I mean, as I said, 90+% of transactions really don't raise any issue, and so you wouldn't need to think too hard about it. But I don't know, a deal that was announced this week, Microsoft Activision, $75 billion merger in a, concentrated, very dynamic, interesting space. You can be sure that Microsoft and Activision would have had antitrust lawyers thinking very hard about, well, can we actually do this? How should we try to make the process run? What are the risks? So absolutely something that you would think a lot about before a transaction even gets out of the boardroom, really. Okay, so let's talk a little bit about the suspension period, which is really the hammer that the European Commission has in all of this. So as you guys know, you can't implement a transaction before its notification or until it's been declared compatible with the common market. That is, until you get a clearance decision. This has been somewhat of an ambiguous situation in some transactions. We'll talk a little bit about some firms have gotten in trouble, gotten fined for violating this rule. But the basic point being, there is a standstill obligation. You cannot implement a transaction before you have a clearance decision, and you have to file a merger notification. There are a couple of yeah, go ahead.
No, sorry. And that is really, really important for the Commission and the whole actually EU merger control system, because the very idea of an ex-ante merger control system is that the Commission can look at the merger before it is consummated, so that in case then there is a problem to be solved, either by divesting some assets, may say that's probably the most notable example, then the assets can be divested before the two companies are combined and integrated, and when the two companies, then the assets still belong to competing businesses and have not yet been integrated. While if the parties were to allow to merge and close the transaction, and then the Commission would come in, be much more difficult to find, in particular, structural solutions that could work and can actually be viable, because probably some integration would have already taken place, and so much more difficult, as I say, to unscramble the eggs once they've been scrambled, which is why really the standstill obligation is a cornerstone of merger control, and we are certainly very active in trying to act against those companies who don't, rarely, hopefully for now, don't comply with that provision.
You can't unscramble the eggs, or what I say, you can't put the toothpaste back in the tube. So that's the reason for the standstill obligation. So there are a couple of exceptions to this, which really mostly draw out, well, at least on the first exception draws out of corporate law. That doesn't have really anything directly to do with merger control. But public bids, so where a company launches a takeover bid under the takeover code of a country, sometimes those takeover codes, as securities law matter, they require that the bid be closed in a certain amount of time, just for the protection of the shareholders of the target company. And there's an exception to the standstill. So you might not have your merger control done by then, but so you have got conflicting rules. The merger control law says you can't close your deal. The takeover code says you have to. So what do? Well, the answer in that case is that you actually can close and acquire the shares in a public bid during the standstill period under the merger regulation. You have to notify it under the merger regulation, and you can't exercise the voting rights of the shares. So you own the target company, but you can't do anything with it. You can't vote the shares. You're going to have to give the shares all to a trustee to hang on to, or something like that, who will kind of run the company as a going concern. And that's really just an accommodation of the corporate securities law rules. And of course, if the deal goes wrong, and you've already acquired those shares, the risk is on the buyer who has done that. So this happened in sort of an ugly fashion several years ago in the Schneider-Legrand transaction, where Schneider announced a public bid for Legrand, notified the transaction, and the commission said, yeah, we give you a derogation from the standstill obligation under Article 7.2. Schneider acquired almost all of Legrand's shares under the public bid that it had launched. Several months later, then the commission blocked the transaction. And we'll hear about this saga a little bit more later on. After the commission prohibited the deal, Schneider was ordered to divest almost all of Legrand's shares. It was allowed to keep 5%. Schneider appealed that prohibition decision to the general court, and you, if you were eagle-eyed, would have noticed that that was one of the blue circles on the slide of prohibition decisions a minute ago. The general court annulled the commission's prohibition decision. So Schneider has bought the shares, done nothing with them, had to sell them. Then they got the prohibition decision overturned in court. But by that time, it was kind of too late for them. Just Legrand had gone on to do other things. It was kind of too late to resuscitate the deal. But Schneider was unhappy about that situation, as you might guess. And we'll talk in a little bit later on about what Schneider tried to do vis-a-vis the commission after that saga. Another exception to the standstill obligation is basically if the target is in a real bad situation. So like if the target is just about to go bankrupt or something like that, you can just ask the commission to give a derogation from the suspension obligation, maybe to allow you to close the transaction, transfer the money, let's say, keep the company operating while the commission's review is ongoing. You're probably not going to get that kind of a derogation if the deal raises competition concerns kind of on its face. The commission will be, for the reasons Michele said, worried about not being able to unscramble the eggs, and so that's going to be hard to convince the commission. But it does happen, right? So in Ryanair Laudamotion, for example, Laudamotion was really struggling, was kind of about to shut down its operations. If you know how airport landing slots work, and you've been some press on this the last couple of weeks, airlines have to keep flying their flights, otherwise they lose their landing slots at airports. That was going to happen. Laudamotion was going to have to stop operating flights. We're going to have to cancel a bunch of flights, and that would have irritated passengers, et cetera, et cetera. And so the commission allowed Ryanair to proceed with the acquisition before getting clearance. But that was, nothing untoward about that. I think it was, just really sensible. It was what you would do if you were to make up the rules yourself. Michele, anything about derogations?
I think derogations are becoming a bit more common than they used to be. We actually start publishing again also some of those so that people can actually see what are the conditions under which normally we grant those. And I second all what Chris said. And more generally, if you are in a hurry to close a deal which doesn't raise issues because the target is in difficulty, the best course of action is go and talk to the case team and to comp who normally are quite understanding of the situations rather than closing and then facing problems. I think is there is flexibility in the rules to accommodate precisely for these situations, and it actually is one which is used in practice. So it's good advice to do that.
What would be suppose the target's not in any danger, but suppose it's coming to the end of the year and the tax rules are going to change as of January 1st, and as the buyer, this is going to cost me a whole bunch of money if I don't close the transaction on December 31st. I would like a derogation because it's now December 15th when we've announced the deal. How's the commission going to look on that kind of a request?
Not going to happen. I think the real the real situation is where there is a real threat for the target viability and for its the soundness of its business. I think commercial consideration between the parties have to be dealt with contractually and not use a commission tool. So no, not gonna happen.
I knew you'd say that, but I thought I would ask it. Okay, so now let's talk about the notification pre-closing. So again, no implementation, and also you have to file a notification before you get your clearance. So as it says, you have to submit a notification before you can close, but before you can close. In order to submit a notification, the parties have to satisfy the commission that they have a good faith intention to proceed with the transaction. That doesn't mean they have to have signed the formal agreement. Oftentimes, those take months and months to do. They're hundreds of pages long documents, but everybody knows that the deal is going to happen. The parties are working toward a deal, but if two CEOs have a meeting in a bar and sign an agreement on the back of a cocktail napkin that says we're going to acquire you for €1 billion, that might be enough actually to let you get the process rolling. It's just really demonstrating that you have a good faith intention to do the deal. So again, agreement in principle, memorandum of understanding, or kind of a letter of intent, really almost anything that manifests that the parties really do intend to do a deal. So again, you've got some sort of agreement, meeting of the minds between the parties, you file your notification, you get your clearance, and then you can implement. What happens if you don't do that is you might get fined. And the commission has become, this has become a much bigger issue in the last few years, I would say. There were rarely what we call gun jumping cases before that. But the last several years, there have been quite a number of them. What does this really mean in concrete terms? It means implementing the concentration prior to clearance, or failing to comply with conditions that are imposed. We'll talk about that in the remedies section later. Failing to notify, failing to submit the notification at all. It's kind of a separate infringement, or implementing a deal in breach of the suspensory obligation. So those are all, they seem very similar, but in some court judgments, they have been found to be independent infringements. In particular, the notification obligation and the standstill obligation are separate infringements. Usually they would go together. You might think, well, if you haven't filed a notification, obviously you haven't, and you've closed, well, you've violated the standstill obligation too, but you can get fined twice for that.
And you normally would.
Go ahead.
No, and you normally would be fined for both. I think now that even the Court of Justice has clarified that the Commission is entitled to have two separate infringements, and so impose two separate fines, yes. One for closing before notifying, and for closing before clearance.
Yep, that's Marine Harvest, if people want to look that case up.
Professor, I have a question. I would like to know the validity of the contract. If the party fails to notify the transaction, is the contract is void or voidable, or is still valid, but they just need to give a fine?
Like a merger agreement?
Yes.
Normally, a merger agreement will include provisions, and these are drafted by our corporate law colleagues rather than us antitrust lawyers, but it will include provisions that say what happens if you don't get all the merger clearances, and it will also include obligations on the parties to file the merger notifications that they need to. So usually in a share purchase agreement or something, there will be a couple of paragraphs that say the buyer agrees to submit merger notifications. It might say everywhere that they're required, or it might list each of the jurisdictions if the jurisdictional assessment is already done. And it says you have to do those as soon as you can or within 15 days or something like that. So it will include that sort of a provision. And it will also say, as a condition to closing, we have to have all these clearances done. And once you have all these clearances, then the buyer is going to be obliged to close the transaction. So answer to your question, I think, is there will be contractual remedies if either of those things don't happen.
An interesting legal question, which I don't think has been explored yet, which is a bit related, is what happens to a transaction which is closed and then blocked by the commission? What happens to the actual transfer of the shares or the assets based then on a transaction which then is subsequently blocked? But that's again, it's more of a academic question, at least for now.
Yes,
Question
because
from
I'm worried
Jan.
about gun jumping cases. If in the gun jumping cases, the party already closed and they already transferred the shares, but later the commission
okay.
find, oh, sorry, it's prohibited.
Yeah, no, I think that's okay. The transaction would go ahead. There would just be a fine for the parties responsible for the gun jumping, but it would not, in my view, impact the validity of the agreement as such. No, Chris, what do you think?
Okay, understood. Thank you.
So again, this is one case, Electrabel, CNR case.
I have another question to that subject. I mean, how would the fine be calculated if the parties found a joint venture? Is the fine then calculated as both of the parties or just the part that concerns the joint venture?
I believe that there's a, Michele will dispute this, but I think there's a fairly high degree of discretion involved in the level of the fine. It can be up to 10% of the party's turnover, but I'm going to let Michele answer how the fines are determined.
The legal answer to your question is if it is a joint venture in which both parties have an obligation to notify, so this is a jointly controlled scenario where both parties are responsible for notification and then both parties violate the standstill obligation, then the notional cap of the fine is 10% of the turnover of each party. So one party can be fined up to 10% of its turnover, and the other party can be fined up to 10% of its turnover. But if you look at the fines imposed so far by the Commission in gun jumping cases, I think the percentage, the average percentage has been 0.4, never even close to 1% of the turnover of the party. So I think the notional cap so far is very far away from the actual amount which has been imposed in previous cases.
Thank you very much.
Okay, so what is this notification form? It's something that we call a Form CO. In big cases, it's a really large document. It may include several chapters, each of which is so thick when it's printed. It includes information about who the companies are, about the transaction, what is the deal, what are you buying, how much are you paying for it. Documents in support of that might, in some cases, you have to present documents to the Commission about, say, management or the board when they were deliberating the transaction or talking about the competitive implications of the transaction. You have to give those to the Commission. You have to define the relevant markets that are affected by the transaction, the product markets and the geographic markets. Provide data, market shares, competitive conditions on all those markets. So really explain all of what's affected by the transaction, what the parties do, where they compete, where they don't compete, who else is in those markets. It's providing information to the Commission It's also, of course, from the perspective of the merging parties, advocacy. You think that you want to present the case in a certain way, and the commission, by asking questions about what you've told them, wants to make sure that they see everything that they need to see in order to understand the transaction. Just again, for context, a simplified procedure, short form CO might only include, if you condensed it down, a few pages of writing, maybe only 5 to 10 pages of writing. A big form CO in a major case might be 1,000 pages. So it's a massive difference between sort of the amount of work that goes into this. But you're writing a form CO, you're oftentimes starting a pre-notification process by submitting a draft form CO, and then you're kind of filling it out to incorporate things that the commission has asked about during pre-notification. And kind of the end of the pre-notification is when you get to the point where the commission says, yep, you've answered the questions that we have for now. Here's the form CO that includes all the information that you've asked us for. Now we formally notify and start the clock running. So I said a minute ago, there's something called a simplified procedure, which is starting to be used in more and more cases. We'll see in a minute, it's I think about 2/3, if not more, of the cases that the commission reviews. And these are really deals that kind of on their face shouldn't raise any competitive concerns. My personal favorite, a joint venture that has no activity or negligible activity in Europe. There's this funny rule that the commission adopted at the beginning of the merger regulation that's been followed by lots of jurisdictions around the world that says in joint ventures, you probably know that jurisdictional thresholds usually work on the turnover of two parties, right? One party has to have a certain turnover over X amount and the other party over Y amount. In an acquisition, it's usually the buyer and the target. Makes some sense. In a joint venture, the two controlling parent companies can be the two, and the joint venture doesn't have to be included. So you can have to report joint ventures in Europe that are between two big companies. If two big global companies do a joint venture anywhere in the world, they have to report it to the European Commission, even if the joint venture has nothing to do with the European Commission, or with Europe, with the European Union. It's kind of a frustrating rule. I hope the Commission might be on a move towards even further simplifying those kinds of cases. But the good news is they're at least eligible for the simplified procedure today. Second one is a move from joint to sole control. So if I own joint control of a company today and I'm buying the rest to buy out my co-shareholders, really hard to see why that should raise any competitive concern. I already control the company today. I'm going to solely control it tomorrow. That's a simplified procedure case. Another one is if there's really no competitors, or if there's really limited competitive relationships between the merging parties. So these ones have a little more of a nexus to Europe, and you could understand. But if the parties are not competitors at all, or if they are horizontal competitors but have really low combined market shares, or if they have a vertical relationship but again low combined market shares, all of those things. So the market share threshold is really just a screen to weed out cases that are not likely to be of very much interest, and you can use a simplified procedure. Commission always has discretion to ask for cases to go in the full procedure. They do sometimes do that. Sometimes companies think the simplified procedure should be applicable, and the Commission decides no, they have more interest in a case, and they can switch it over to the normal procedure if they want. But again, this slide is missing a piece of pie, but what you see at the bottom there is simplified procedures. 78% of all the notifications are simplified procedures. So what junior lawyers in law firms like mine do a lot is write simplified procedure form COs. That's a task that will be sort of a day one type of task for a junior lawyer at Cleary Gottlieb.
One thing we're trying to do further is to actually further simplify the simplified. We've launched only in the end of last year a process aimed at streamlining the notification requirements for simplified cases, expanding the categories that Chris showed to you in the previous slide as to what cases would fall under the simplified procedure, to have even more cases than today falling under the simplified, and for those who fall under simplified, to simplify the information requirements even more. Hopefully that process will run its course in the course of this year. So we'll have a new implementing regulation, a new simplified notice in place shortly. They're not gonna solve the issue that Chris mentioned the previous slide. That is, they're not gonna eliminate the need to notify to the Commission joint ventures between parties whereby the joint venture does not have any or has very limited activity in the EA, because that requirement comes from the merger regulation, not from the implementing regulation. And the merger regulation is a different animal in terms of amendment, because it's not a Commission document, it is a Council regulation, which requires not only a Commission proposal, but also unanimity of the Council to be changed. So it's a much more longer and complex process. But so no, we cannot change the notifiability of those transactions, but as Chris was hoping for, we're trying to further reduce the type of information which needs to be supplied in those cases.
Great. So what do you do, or how do you know that you have to tell the truth in your notification? Well, the rule says in the implementing regulation says you have to. And the merger regulation says if you supply incorrect or misleading information, you can get a fine. This has, in fact, happened several times. This slide talks about Facebook WhatsApp. A few years ago, Commission fined Facebook 110 million euros for providing incorrect or misleading information in its notification of the acquisition of WhatsApp. This is a deal that, as people, if you look at the Financial Times or things like that, still seen as a controversial clearance decision. Facebook at the time, so what did Facebook say at the time that led to this? They said that it wouldn't be possible to automatically match the user data from their Facebook account against WhatsApp phone numbers. So kind of merging the two, which would have been, one of the theories that the Commission would have looked at quite closely. Are you going to merge these two things and have some sort of foreclosure effect as a result of that? And Facebook said, nope, we can't do that. We can't do that. But the Commission got wind that might not have been so, started poking around, and eventually WhatsApp admitted that it actually was possible to do that. I don't actually know whether Facebook implemented that or has implemented that today, but the Commission got wind of this and fined Facebook 110 million euros for that. So that's the sort of thing that will very much get your attention as a lawyer who drafted that Form CO. Your client getting fined $110 million for something that came off your keyboard at some point. Quite an eye opener, really, and not something that a company wants to have on their record, or the law firm that's working for them. Some other cases, Merck, Sigma, Aldrich. The Commission looked at both parties in this one, dropped the objections against Merck, but this past year fined Sigma Aldrich for providing misleading information. GE LM Wind Power, the notification that GE had first submitted didn't include some information on a specific, I think it was an R&D project that was ongoing, and the Commission cleared that transaction too, but fined GE 52 million euros for failing to disclose this R&D project in the original notification. That one probably go ahead, Michele.
No, and to be clear, these are not that we look for like some secondary sentence in a 200-page notification and try to prove that wrong. These are only 3 cases. They were issues which we've asked the parties several times during the pre-notification and the notification. For example, do you really have the project? No. Are you really sure you don't have the project? No, we don't have that. Are you really sure you don't have the project? And then they kept saying no, and then turned out not to be right. So it just, and they were all important elements for the assessment. So I think these are the parties have the opportunity to rectify incorrect statements that they've made during the process if they're made in good faith and nobody makes a fuss because everybody's working under pressure and with imperfect information. It just if the issue becomes central to an investigation and the commission insists on it and still doesn't get a truthful reply, then we can take issue with that.
Yep, and I think it's a key point on this is incorrect or misleading information. It doesn't have to be purposeful. It's not necessarily that these companies lied, yeah? It just may be that they didn't ask enough questions internally to figure out that this, this program existed. So there's quite a high amount of diligence internally. A company like General Electric's got hundreds of thousands of employees, and it takes a lot of effort internally on the companies to make sure that you get this stuff right, but it's really important to do that. Small point about withdrawal of notifications. This happens reasonably often, that you're allowed, once you filed a Form CO, you're allowed to withdraw it. And usually that happens, obviously if the deal falls apart for whatever reason, you would withdraw your notification, you don't need your clearance decision anymore. Or more often, well, I'll ask why. Suppose the commission was about to prohibit a transaction. Why would you might want to withdraw the notification? Anybody in the room? Till is sitting in the front row. I'm going to call on Till. Till, why would you do that?
I think from a practical perspective, maybe to avoid any costs.
Avoiding costs?
Because probably the procedure is not for free.
One reason. That's one reason. Lawyers aren't as expensive as you think. No, costs would be one reason.
I may have an answer to that.
Yeah.
Firstly, if I recognize that I made a fault, so I could just withdraw it and say, okay, I'll bring in the form again, but with added information. Or secondly, because I want to give the commission more time, in fact, so I withdraw it and bring it in again. But I believe the commission has the possibility to give itself more time.
Yep, those are both good points. So on the withdrawal to get more time, that happens in phase 1. So if you think you just need another 2 or 3 weeks and maybe you can get this over the line and you don't really need to go into phase 2, you can withdraw a notification during phase 1 and then resubmit it, restart the clock, buy yourself a bit more time. You probably wouldn't do that if you were in a phase 2. So the situation I have in mind is you've probably gone through quite a bit of the phase 2 process. Things are not going well. You're worried that you're going to get the deal blocked. Why would you want to withdraw the notification?
Because then I can alter the deal and bring it in again instead of having a completely blocked deal, because if it's blocked, it's blocked. So I have to, when I bring it in the next time, argue even more how this is a different deal than the one that just got blocked.
Potentially, that's a good one. That's kind of a little bit the MCI Sprint deal that's on the slide right now. The parties were sort of holding out the possibility that they might have wanted to change the transaction. You see, though, the commission didn't like that. The parties withdrew that merger notification, and the commission actually issued a prohibition decision the very next day. So they might not have been, the commission might not have been sure what the parties were doing there. So as you see at the bottom of this slide, the commission subsequently made clear that if you're going to withdraw a notification, you got to really prove to me that you've abandoned this deal. So probably not going to let you do that if they think you're just going to tweak the transaction in a certain way.
And I guess that's a difference in phase 1 and in phase 2, right? In phase 1, you can withdraw your notification and still have your deal signed and present the notification again a few weeks later once you've sorted out all what you needed to sort out. In phase 2, we would not accept a unilateral withdrawal. We would simply accept an abandonment. So the SPA or the merger agreement has to be terminated. So we need to see evidence of an agreement that the merger agreement is no longer there. Transaction is no longer on the table. Only on that condition, we would accept not taking a decision at the end of a phase 2. There's no unilateral withdrawal in phase 2.
So the next slide's going to answer a little bit my question, which there's been several reasons, but people haven't put their finger on the reason why I think this transaction was withdrawn. This is Halliburton Baker Hughes, oil services transaction. It was a 4-3 deal that was getting reviewed in Europe and in the United States. So you see, and we'll go through some of these steps later on. We don't need to cover them all right now. But they signed a deal, announced it, filed their notification in Europe, went into phase 2 in January, had some clock stoppages, but was going quite deep into the phase 2. It was going to end at the end of May, and in early May, the parties actually abandoned the deal and withdrew the notification. I think a reason why they would have withdrawn the notification there is they don't want the commission to publish a decision, a prohibition decision, that might have included some precedents on things like market definition or dominance, things like that the parties would rather not have out there. If they think the deal is going to get blocked anyway, they might just rather abandon it and not have it be prohibited and have a precedent that about their company that is out there. Wouldn't happen every time, but it happens somewhat often. So usually when we count number of commission prohibition decisions, there are formal prohibition decisions. That's the 30. But on top of that, there are probably another, I don't know, at least 10 cases, of which this would be one. This deal was almost certainly going to get blocked. It was abandoned. Doesn't count in the statistics as a prohibition, but it was going to get blocked. So the number of prohibitions in effect, if you count these, is more than 30.
Only last year, just to give you an example, Chris mentioned in one of his first slides that we blocked the merger last week and was the first prohibition in some time. But last year, 2 airline deals were abandoned in a very late stage of phase 2, similar to this one was IAG Air Europa in December and Air Canada Transat in the earlier part of the year. And both deals were in a not too different situation from this, the one that Chris has here up on the slide. But there was a question, I think, or somebody wanted to intervene.
Yeah, I have a question, but is that really practical? Because I don't believe the commission would just, if there's the next deal on this market, I believe the commission would look at its prior decisions, even if they were not published, and say, hey, we looked at this market before, so is that really a good reason to withdraw?
Yeah, look, like on the blocked merger, the commission would not look at the same transaction within a short time unless the parties are able to show that the market situation has changed compared to the time when the commission issued its prohibition. So in an abandoned merger at a late stage of the game, like the one you have here, there's no formal, if you want, impediment for the parties to represent and re-notify the same transaction if they were to abandon it and re-sign a new deal and represent it. That said, you're right. I mean, most of the assessment, unless there are big changes in the market, will be similar. One thing which may change is remedies. The parties may have had more time to rethink about their deal, renegotiate the purchase price, think about themselves, how can we solve this problem if you really want to find to get this deal done. And so they may have better ideas on remedies that the one they could have had the first time around. That's the one that it comes to mind as one of the reasons why you may want to do it. I know, Chris, whether
yeah, when I agree with that. And one other reason, I mean, of course, you're right. The European Commission is not just going to forget everything they did, up until early May in this transaction, but third parties won't get their hands on a Commission decision that might say things that would be, they could use to the disadvantage of the merging parties. So I think that's a consideration you'd have in some cases.
And also perhaps, I don't know, I'm guessing the impact on share prices. Like if you have something blocked, I guess it's more prevalent in the market and could be perceived a little bit more negatively than, the companies deciding not to go ahead. I don't know what happens to share prices when they're blocked.
Potentially. So yeah, it's not a great headline when you have your merger blocked.
There is also the PR angle of it. Besides maybe the share price, is also purely the PR angle around the company and the way the company wants to come out or not in the press in a certain way.
Okay, let's go on to another a specific issue that I think is kind of a fun one. Parallel mergers. So this is suppose that there are an industry in which there are, say, four major players. So really concentrated industry with four major players. Two of these parties want to merge and the other two want to merge. And those two deals are happening more or less at the same time. How should the Commission treat those? You could envision a few different possibilities. You could give one deal priority over the other. And if you're going to do that, how do you decide which one? You might give priority to the first deal that gets publicly announced, for example, or you might give priority to the first deal that's had a Form CO filed, for example. Or you might not go with a priority rule at all. You might just have a kind of a combined assessment where you assess both deals, kind of assume they're both happening and just kind of assess them both in the aggregate, assuming both deals go ahead. What does the Commission do? How has the Commission settled this? They actually settled on a priority principle based on the day when the Form CO is filed. So no combined assessment, not considering both deals together, and not giving priority to the first transaction to announce. I'm going to ask Michele whether this is fair.
I know. I was a colleague of yours working for Western Digital at the time. So at the time, it seemed to be very unfair because we were second ones in that race by 1 day. So we didn't feel fair at the time. I think that it hasn't happened since. It hasn't been tested before the court either, because in the end, Western Digital did not proceed with the appeal because they found a solution for the transaction as well. I think if you want to have, if you need to have a rule, probably any rule is as good as the next one. So as long as it's clear which one it is, people should know and then abide by it. I understood at the time that the US they were taking a more of a different approach. They were looking at your third scenario, so looking at the two transactions together to the combined market impact, and then potentially they would have design remedies accordingly. I know it is fair. It's just a rule which perhaps is a bit arbitrary, but at least now there is a rule.
Okay, so you have flagged the Western Digital case, which indeed is the illustration of this. So what happened in this case? So you've got builders of hard drives. There were sort of four of them, four major ones in the market. Western Digital publicly announced a deal in March, started the pre-notification discussions with the Commission. Unknown to them, the other two players in the industry were also going to merge, and we're also doing pre-notification discussions with the Commission. And in a very shocking day for Michele, April 19th, 2011, Western Digital learned that Samsung had filed a Form CO for its deal. While Michele was having cordial pre-notification discussions with the Commission for Western Digital, this came as something of a surprise, no doubt. The second transaction had not been publicly announced. So it was all done in secret. And what did the Commission do? Well, in the end, they treated the Seagate Samsung deal as a 4-3, and that deal got unconditionally cleared. They treated the Western Digital deal as a 3-2. So assuming that the Seagate Samsung merger had already happened, and they got hit with big time remedies to get their deal cleared. So I have written, I agree with Michele, any rule is better than no rule. But it seems to me that a trigger based on public announcement is a bit more fair. This rule as it stands now, fortunately, doesn't come up very often. If it did, I think the Commission would have changed it because it puts immense pressure on the case team, as you can imagine, to keep things confidential when there's a race going on, but the only people who know that is the Commission, right? The Commission knew there was this race going on, and Seagate Samsung knew there was a race going on. Western Digital didn't even know there was a race going on. You know, it can be a harsh result.
Yeah, one point is confidentiality. The other point is making sure you ask exactly the same questions to both parties in pre-notification, because you don't want to be the cause of the delay of one or the other file. So you have to be entirely, if you want, very thorough and very precise in not being the cause for the late notification if you take as a rule the first to notify. So I agree with Chris that I mean, it's not perfect, but again, not something which has come up since.
So let's talk a little bit about gun jumping, which is what we've mentioned a bit earlier. So say this is a little bit old slide, but you see around the world, there have been authorities issuing fines for parties who didn't file notifications in their countries and their jurisdictions. It's been going on for a few years. It's really gotten recently kind of more prominent in Europe in particular. A case that got a lot of attention, still gets a lot of attention, is this Altice judgment, which I'll talk about in a second, where Altice got fined 125 million euros for gun jumping, by far the biggest gun jumping fine ever issued. And so what was this case about? Well, this was a telecoms merger. Altice was acquiring a company called PT Portugal. They notified the deal. They got a conditional clearance decision. So it wasn't that the transaction got prohibited or something, but what happened was, even in the merger agreement, Altice got quite a lot of extensive rights to direct what PT Portugal would do or not do, kind of even during the time that the merger review was ongoing. And it actually exercised some of those rights. So they were advising on things like contract negotiations that PT Portugal was having while the Commission was reviewing the merger, before the Commission clearance decision had been given. There was also quite a bit of information exchange, competitively sensitive information being shared during that time. And the Commission found that those actions were in violation of the standstill obligation. Altice really had kind of taken control in important respects of PT Portugal before the Commission clearance decision was issued. The Commission fined Altice 124.5 million euros, and just last fall, the General Court upheld that fine on appeal.
And again, Altice was our case, and I think that an interesting just anecdote as to how this came about. I mean, we were discussing with the parties, with Altice, pre-notification, as Chris was hinting before, like in particular a good remedy to have in phase one to get this transaction approved in phase one and avoid the phase two investigation. And during the purification, or even during the phase one, the
Another deal with a gun jumping fine, a pretty significant one, different structure. So this was not so much, I think Altice was aggressive and a bit sloppy, as Michele said, in the drafting and the rights that they acquired immediately upon signing that deal. Here was a different situation where the Canon Toshiba, where the parties kind of understood that what they wanted to do, that they had to, there's usually these deals come out of a situation where the target really needs the money soon. So there's a lot of pressure to close and give them the money soon. And what did Canon do in this case? So the Toshiba business, they transferred 95% of the shares of the business to a holding company, a special purpose holding company that Canon didn't manage, independent entity. And then Canon paid 5 billion euros for 5% of the shares, for the other 5%, plus an option to acquire the 95% for like next to nothing. They filed the notification, the commission approved it, and then after that, they exercised the option to get the 95%. What the commission found was this was something called partial implementation. They said, look, you didn't really pay 5 billion euros for 5% of the shares. You really bought the company and you just kind of tried to split this into 2 steps, which is totally what they did. So this led to this development of this doctrine called partial implementation, where if you have a transaction that's kind of done in 2 steps, but they're both in furtherance of what's really one goal, you can't implement the first step. Implementing the first step is going to violate the standstill obligation. So those if 2 transaction that's done in 2 steps, they're kind of conditional on each other, and they're really part of a single project, the commission's going to find that you shouldn't implement the first step before you have your clearance decision. So just to tie off gun jumping, what can you do? Well, you can plan to integrate the businesses. You can set up, as Michele said, clean teams of people to kind of share information. And you don't want to be, on the day when you do close, you don't want to be starting from zero. So you can plan to integrate the businesses, think about what you're going to do when the businesses are together, and you can have teams devoted to that sort of planning. But you have to carry on business as usual until you get the clearance decision. The companies need to operate as independent competitors. They have to stay separate. They can't coordinate their strategic activities. They can't coordinate customer activities, that sort of thing. Don't implement the deal. The buyer can't get control in the defined sense of that term over the target. Don't act as a single company. Don't share information that you otherwise wouldn't share until you have approval. EC's powers of investigation. Michele, I thought I might just give you this couple slides to.
I have a question regarding the previous slides.
Sure.
In order to plan the implementation, is it possible to get in touch with the client to ask for information or to start negotiating future?
I mean, you can get in touch with your own clients and see how they would, see dealing with an integrated entity. Is not a good idea to discuss future prices or strategy with the clients of your target. I don't know, Chris, what you think?
Yeah, sure. I mean, there's lots of stuff you can share, right? You can share information mostly, I don't know, related to HR. What's our team going to look like after the deal? That kind of stuff. You can plan. That's what we would call integration planning, but you can't be sharing competitively sensitive information that you wouldn't share in the absence of a transaction.
Okay, thank you.
Yeah, happy to take this, Chris. So how does the commission get the information that it needs to assess the possible impact of a merger on competition? I mean, an important source is the one that Chris talked about before, the form CO, so the notification, where the parties essentially have to give a number of information to be able to get the clock moving, so to get transaction notified, but also where the parties will advocate a bit their case, because rightfully they want to present the case in the most favorable way for them, while still being truthful in terms of market definition, market shares, competitive assessment, barriers to entry, all the parameters are relevant for the assessment of a potentially complex transaction. What the commission normally does during an investigation is to somehow try to double check that information with the market. And how does the commission does that? The commission does it by sending requests for information, or RFIs, which are typically sent in both in pre-notification and then during the formal notification process to customers, competitors, industry associations, whoever the commission think may have information that are useful for its assessment, often to double check or confirm what the parties have been telling the commission in the notification. And that already happens during the pre-notification, so that the commission can already interact with the merging parties on the draft by also based on input from the market. The commission can also send a request for information to the notifying parties, both in pre and after and post notification. And again, any party which is the addressee of an RFI is, if it decides to reply to it, it has to reply to it in a truthful and complete way. The commission has meetings, or now virtual meetings, with the parties, third parties. Often in transactions you may have some complainants, typically competitors, but sometimes also customers who are unhappy about the merger and are proactively feeding the commission with data and information. And that can happen through RFIs, but also through ad hoc submissions or through meetings, which the commission has to have minutes of, and then share the non-confidential version of those minutes with the notifying parties, which of course need to have access to it to understand what happened. Meetings or telephone interviews is essentially the same thing. The commission can theoretically conduct inspections in mergers, meaning surprise inspections at the premises of the merging parties, for example. That hasn't happened recently, hasn't happened in many years. And the reason for that is that essentially inspections are time-consuming to prepare and then time-consuming to follow up, because it takes time to have a team in place to carry out inspections. It takes time then to review the results of inspection. It normally results in several hundred thousands of documents being gathered, and then hopefully have to be filtered through previous discussion with the parties. So it just takes a lot of time, which often is not compatible with the timeline of a merger review. So the main tool for the commission to investigate in mergers is RFIs, meetings, telephone interviews. Yeah.
You could also imagine a dawn raid in a merger context, creating a slightly poisonous environment between the parties and the
On top of it, yes.
Everyone would like to avoid that.
Exactly.
Possible.
Exactly. Okay, no, sorry, go ahead.
Go ahead.
No, as I was saying before, I mean, our system is perhaps different from the US system, and what we think is that the parties, the merging parties, have to have access to the commission's file at some point in the process to be able to see a non-confidential version of the evidence that the commission has gathered during the investigation. We don't have any access to the file in phase one. We're going to get now to the two phases, but I mean, in phase one, the short 25 or 35 working days phase, the parties have no access, no right to have access to the file. The parties have no right to access the file at the beginning of phase two. They can only be given some key documents that the commission has gathered during the phase one, but no formal access to the commission file. The moment in time as of which the parties can have access to the file is the issuance of the statement of objections. I think we're going to get to what that means in the future, but in the coming slides. But essentially, as of when the commission formalizes its preliminary concerns about the merger, the parties have the right to have continuous access to the file up essentially until the end of the merger process. And that essentially would encompass all documents that the commission has gathered during the investigation, of which it has a non-confidential version and which it relies upon in its investigation. So it's a fairly cumbersome exercise for the commission to put together, but then of course even more cumbersome, equally cumbersome for the parties to then weave through and use it to support their arguments in the interaction with the commission.
Great. So next we're going to go through a little bit the step-by-step of phase one and phase two. So you see how these cases typically run. And as we talked a little bit before about that the timeline can vary quite a lot. This is, say, indicative, but just to show you more, not necessarily how long things take, but what happens. So typically you announce your transaction, you start your lawyers working on the notification process. And the first thing you would do in a normal kind of case is file a draft Form CO. You might start talking with the commission case team before that. So you're going to have a case team assigned. The very first thing that will happen is you'll have a case team assigned to the matter. You start working on your draft notification and kick off pre-notification discussions with the case team. As I said, that can last anywhere from a couple of weeks to many months. Once the case team is satisfied that they have what they need and they don't really have many more questions at this point, you file your formal notification. And in phase one, the commission's formal review period is 25 working days. So that's if the case is going to get cleared unconditionally, you will have a decision within 25 working days. If the commission sees issues in the case, sees concerns, you'll have something called a state of play meeting, which is a formal meeting with the case team where the case team tells you essentially, look, we have these issues. You either fix them or we're going to go to phase two. So you see after 25 working days, you have a phase one clearance decision. 35 working, if you're going to propose commitments during phase one, you get an additional 10 working days, which is not very long in the circumstance, to work through the remedies. So 35 working days is the time period for a phase one with remedies. What can happen in phase one? Well, inapplicability barely ever happens. Referral of the case to a member state in whole or in part happens occasionally. Unconditional clearance, as we saw from the pie chart, that's the main one by far. Conditional clearance in phase one, that's clearance decision with remedies. You can give remedies, give commitments during phase one. That happens very often. And why do you do that? Well, because you're trying to avoid going into a phase two investigation. Or the commission opens a phase two investigation. And the standard there is the commission has serious doubts about the transaction's compatibility with the common market. I think as a practical matter for emerging parties, going into phase two is very often a quite traumatic, quite shocking, something they really, really want to avoid. And serious doubts sometimes doesn't seem like a very high bar to get over. And that really pushes companies oftentimes to try to get remedies done in phase one. So again, almost all deals are approved in phase one, 97%. Phase two cases are rare, and I think they're becoming even more rare in recent years as the timetable has extended and Commission has, the practice has shifted more to the front end, more to pre-notification than to just kind of get your Form CO in as soon as possible and let the process run. So phase 2, what does it look like? Again, we're just continuing from the timeline of the previous couple slides. So you open phase 2 and the Commission is going to start working on a statement of objections. There's going to be lots and lots of information requests, very intense period of back and forth information gathering, providing information to the Commission. The Commission will work toward drafting a statement of objections, which is kind of the complaint document. And we'll issue a statement of objections. As Michele said, when that happens, the parties get access to the Commission's case file. That's all the documents in the file that they intend to use as evidence in support of their case. The parties reply to the statement of objections. That's a written document, can be several hundred pages in a major case. Move toward an oral hearing. That's a hearing in front of the interested parties and member states and others from other wider audience from the Commission. Get into then remedies deadlines. So you have deadline to submit remedies with 55 days. If you submit remedies within 55 days, there's no clock extension. Then 65 days is the official remedies deadline. And then you really get down to brass tacks at the end, another state of play meeting after the remedies are in. And then it gets from that point, it gets a little bit less transparent, but you pretty much need to know on this transaction by August what's going to happen. If you're going to get your clearance decision, day 105 is theoretically 105 working days is theoretically the longest that a phase 2 can go, but or is theoretically the length of a phase 2. But in practice, they all last way longer than that. There's clock stoppages in every case now, and so they all last quite a lot longer than that. But your decision will come. Go ahead.
No. No, finish and then just you complete and then.
No, and then I was just going to say, you get your decision, and well, if you've got remedies, which is most of the time the case in phase 2, you start implementing on whatever the remedies are.
I was just going to add that, of course, all the steps you see on the slides may happen, but not all have to happen. In other words, you have phase 2s where the parties decide, for example, to offer remedies early in the phase 2, so before the Commission issues a statement of objections. And so it is possible that the Commission is happy with remedies which it has market tested, so on which it has sought market feedback already pre-SO, so that the phase 2 can be shortened. The Commission doesn't have to draft an SO, and all the, if you want, a reply and hearing process doesn't have to take place. That happens, is not common, but is also not unheard of. If the Commission issues an SO, the parties, as Chris says, of always reply in writing. Sometimes they ask for a hearing, sometimes they don't. I think that is a more varies, I think, depending on the case. Chris may tell you more about the tactical considerations around asking for a hearing or not, but it's not the rule that a hearing takes place. There are plenty of cases where the parties prefer to have a technical meeting with the team as opposed to a formal, fully fledged oral hearing. And on the last part of the process, is also true that your deadline may be, as in this case here, end of September. In an extended variation of the phase 2, it is also true that for all practical purposes, given that the back end of the process is very much inwards looking in the Commission, it is consultation with services, consultation with member states, formalities around the adoption process. The outcome of a case, unless other than in very exceptional cases, is set already quite a few weeks before your final deadline.
Right. We'll come to some of those specific steps in just a moment. So the phase two, again, the investigation is conducted by the same officials as phase one. It's not always the case. For example, in the UK, you go into phase two, you get a whole new case team. It's kind of like pushing the reset button and starting all over again. Advantage, well, maybe the people who put you in phase two have already decided that they don't like your transaction and you get a new audience. Disadvantage, you have to start all over again and you don't get the benefit of working with people who have looked at your deal, understand your industry, etc. All of this slide is to say that phase twos are very intense, very burdensome. They take a long time. It's good that there aren't very many of them. They're very difficult processes to go through. So any case that's in phase two that you see in the headlines going into an in-depth review, they're really having an intense regulatory process. Statement of objections, again, that's essentially the Commission's complaint document. I guess where the important points on this is that the Commission must issue a statement of objections if it intends to block a transaction. And the SO has to address all the matters that it's going to that the Commission is going to rely on in a prohibition decision. We'll see in a second that if a statement of objections doesn't include something that the Commission relies on in a prohibition decision, that can be ground for appeal. So this was the case in the Schneider-Legrand case I mentioned before. So the Commission SO was based on overlap activities, so like a horizontal overlap case. But in the prohibition decision, the Commission also cited conglomerate effects, and that wasn't in the statement of objections. And so the Schneider said on appeal that, well, we didn't get a chance to even contest these conglomerate arguments. They just showed up in the prohibition decision, and the General Court said, you know what, you're right. That's against your rights of defense, and that for that reason, the Commission annulled, the court annulled the Commission's prohibition decision. Response to the statement of objections is, again, usually a detailed written document, essentially pointing out, it's almost your last shot to convince the Commission that their concerns about your transaction are not supported by the evidence, are wrong. Sometimes they're successful. There are cases where the Commission has issued a statement of objections, heard the parties in response, and actually withdrawn objections. And so there are unconditional phase two clearance decisions where the parties received a statement of objections. They're rare, but there are some. Access to file, Michele mentioned a minute ago. So you get access to the Commission's case file after you receive a statement of objections, and you use that as preparation for your, or as material for your reply to the SO, and in preparation for an oral hearing if you want one. You get to see all the evidence that the Commission intends to rely on for its decision. Sometimes there are third parties that are concerned about, if they've complained about a transaction, they don't want to be identified, and the Commission usually will help them to make their documents are anonymized, so the parties can't tell who submitted them. And the oral hearing, so we can pause on this one for a moment. This is a hearing, like a court hearing. The merging parties get an opportunity to have an oral hearing after the response to the statement of objections. And this is, if you have it, really kind of your last shot at a full, let's try and sway the opinion about our transaction. It's attended by the merging parties, third parties who have shown an interest in the transaction, the Commission case team, other Commission officials, member state representatives. So you have a wider audience. It's kind of a big event with maybe 100 people in the room. It's chaired by a hearing officer. It's the right of the merging parties to have an oral hearing. Michele alluded to this earlier. There are lots of cases where the merging parties don't want to have an oral hearing. They decide not to. I think the reasons for that are really two. Maybe there are more, but two main ones. The first is doubt as to whether it's really an effective means of presenting your case. Oftentimes, attendance from member states or other commission officials isn't as senior, as robust as the merging parties would like. So you don't really have an audience that's all that different from the case team that by this time you've been talking with for months and months, and you already know what they think and they know what you think. The other reason, maybe even more important, is it really gives complainants to the transaction a forum to make their points kind of known more broadly, because the complainants, third parties that are interested in the transaction, can make presentations too at the oral hearing. And oftentimes, merging parties don't want to give complainants, often who are their competitors, say, they don't want to give their complainants that kind of airtime. And so for those reasons, they might decide that it's just on balance not a good idea to have a hearing.
And I agree with all what Chris said. I think the oral hearing, the oral hearing, if it takes place, is not normally a good day for the case team, because the way it is typically structured, you would have a short introduction by the hearing officer who presides the meeting, then 10 minutes max from 9 to 10 past 9 in the morning for the case team to present in a very factual and impartial way the findings of the SO that everybody knows by then, so nothing new. And then you're there from 9:10 in the morning until 7 p.m. the parties bashing the case team for hours and hours and hours on the law, on the economics, on the evidence, with the help of business people, economic advisors, and all that in the presence of the legal service, which I think still by then would have some exposure to the case, but not perhaps a lot, by the cabinet of the commissioner, who also by then may know something about the case, but not a lot, by senior management within COMP, and as Chris said, also potentially by member states, in theory, member states authorities and other commission services. And yes, it's true that you get the complainants to speak, but normally they speak from 7 p.m. to 7:20 p.m. and 5 of them in 4 minutes each. And so it's hardly when everybody's tired. So I think on balance, it is a good day for if the parties can use it properly, the hearing is a good day for the parties and normally not a good day for the commission. And it is an opportunity to make legal and political points about the case to a broader audience. So I think on balance, normally, if the party use it well, can be a good forum. Of course, there's no rule for that, but yeah, that's my own view.
So the parties get to have one good day in their 10-month phase 2 investigation. It's only fair. And as I say, there is this special role, a senior role called the hearing officer. And what this person does is really enforce the right to be heard, that the hearing is properly conducted, it's objective, decides who gets to present and who doesn't, things like that. But this is a procedural role. It's not a decision maker role. So commitments and undertakings, we're coming to the end of this first session. Lots of cases, as we've seen from the pie charts, lots of cases are resolved by way of remedies that the parties offer. The commission is to approve a deal as soon as the serious doubts that led to the opening of phase 2 are removed by way of commitments. So you've got a remedy deadline during phase 2. You can sometimes tweak remedies after that date if you've kind of got a good faith rapport with the case team. You might be able to tweak things after the deadline, but generally not. because the commission needs to go out to the market, to third parties, and ask them what they think. Do these remedies address the concerns that you have about the transaction? In view of these remedies, is this transaction going to adversely affect competition or not? A couple of slides on rights of third parties in merger control. So third parties, that's competitors or customers usually of the merging parties. They have a right to be heard if they can show an interest in the outcome of a transaction. Again, the commission will usually consider the views of customers, suppliers, competitors. I think somewhat, maybe Michele can comment on this, whether like employee representatives or things like that. I think from my perspective, the most important, the most instructive views are probably given by customers of the merging parties, but oftentimes the most motivated third parties are competitors of the merging parties, who have maybe interests that are not the same as what the European Commission is trying to uphold in a process. And Michele, maybe you can speak a little bit about how the Commission looks at the different sources of information from third parties in terms of credibility, etc.
No, Chris is totally right. I think that the customers, if you want, are those who have more to lose from merger, or to gain potentially. So are those who normally would expect to give you the more, if you want, pro-competition or independent feedback on the impact of the transaction, or at least non-biased information. Then, of course, the customers also have potential ties to the parties. No feedback is perhaps totally innocent, especially in complex transactions. Competitors may also have their own interests. They may not like the transaction because they fear that the merger entity will become too big. Some of them may like a transaction because they may think there will be less competition, so they may also profit from less competition going forward on the market. So all interest and input the Commission receives in an investigation has to be filtered and carefully assessed, trying to filter out the biases which are inbuilt in most of these submissions. And so that what the Commission should try to do and to try to seek facts from the market and not opinions, because the facts are those who are actually there to double check what the party is telling you in terms of information. Of course, nobody's perfect, and sometimes one can also listen to opinions. But I mean, the idea would be to try to get to focus on factual input rather than unsubstantiated opinions by whoever, whether that be customers or competitors.
The last couple of slides, and then we're going to take a 15-minute break, is really just illustrations of the media. Some of these deals do generate a lot of publicity. They get interest in the financial press, and with views of third parties that are politicians who have been interested in transactions might comment in the press. And there's just a few slides here that are, I'm not going to go through all these quotes, just to say that often the discussions, the political discussions about major transactions that are going through detailed, difficult reviews are published. And I think, Michele, I'll just ask you to comment generally on how does the Commission even read the newspapers? Does the Commission care what's in the press? Does this influence the thinking behind the scenes at all? My own experience is that most times the merging parties want as little publicity as possible. They just want their deal to be under the radar as much as possible. But when you see stories like these, or people making points, complainants making points in the news, in the newspaper about transactions, politicians commenting on deals, whether they like them or don't. How does the commission digest all of this when it comes out?
Yeah, well, I think, Chris, your advice is the soundest as usual in terms of the less attention around the transaction, the better for the parties. Of course, you cannot control third parties. You can control your own clients, perhaps, but not what other people who may have a stake have to say. And so the question is also, if somebody goes public quite negative against your merger, whether does it make sense that you try to rebalance the public debate? I think the public debate plays a role, at least a contextual role. I think we do read the press, the commissioner does read the press, and people around who may have a view read the press. So I think at least what is achieved by making a noise on the press is that the transaction gets visibility, or at least an aura of visibility around it. As you say, the parties may not want it, but third parties may want it. What is not helpful most of the times is political intervention in support of a merger or against. I think any political intervention, publicly or privately for that matters, is never welcome. But I mean, I don't think it does play a role at the end of the day on the outcome of a case. It may play a role on the attention paid to a case by the team, by us, by the commissioner. I don't think it meaningfully impacts the outcome, but it may create a bit more fuss around the transaction, potentially for no reason.
Great. That's it for the procedure section. So let's take a 15-minute pause. Be back to talk about remedies and judicial intervention.
So see you at 3:30.
Okay, Valerie is herding the cats back into the room. Right, so second section today, we will go here until maybe 4:45 or a little bit later, and then have another break, and then do a Q&A session with Michele at the end. So first topic of this section is remedies. This is what do emerging parties do if the commission has concerns about a transaction and you don't want to get it prohibited. How are you going to fix those concerns? And then we'll talk just for less time at the end about judicial review. So the commission can't clear a transaction that it thinks is going to significantly impede effective competition, but it can condition approval of transactions on commitments that change the transaction so to make it compatible with common market. I think it's probably fair to say that over time, the commission's practice on remedies has really become a lot more rigorous, a lot more demanding in terms of thinking about, is this remedy really going to restore effective competition? And that means what's included. Usually we're talking about divestiture remedies, what's included in the divestiture package, who's going to buy it, what are the structures by which the remedies is going to be implemented, and help from trustees in terms of monitoring how this is all being done by the parties. I think the commission is very much open to remedies. Remedies aren't bad. There are lots and lots of remedies cases, many more cases cleared with remedies than prohibitions. But remedies discussions are pretty detailed, and the commission is a stickler for details in this area. So what are the main types of remedies? Really two. I kind of view access commitments and behavioral remedies as subcategories, but the main one is structural remedies. So that's divestiture. Divestiture of a business, right? If two companies merge and we both make a certain product, that's the same. And there's a horizontal overlap that's raising concerns. We might have to sell one party or the other's business. That's what we call a structural remedy. And that's the most common type of remedies that are accepted in merger cases. Two other kinds, access commitments. I think this is probably the least common type of remedy, but that's access to infrastructure. Suppose that two telecoms companies merge and they have a certain amount of spectrum that they would own. They might solve that concern by giving third parties access to that spectrum so that they can operate on it independently. And then behavioral remedies is really commitments that the company will behave or not behave in certain ways. The commission is usually not going to accept behavioral remedies in horizontal cases. Like a behavioral remedy that you might think of might be, well, the commission's worried that we're going to raise prices because we're both competitors in this market, and the commission thinks we're going to raise prices. And so the business people often say, well, okay, what if we just promise not to raise price? You might think that would work, but Michele will not be welcoming of that sort of remedy at all, because it's too complicated and it's not really just allowing the market to function as it should. But other cases, vertical or conglomerate cases, suppose the concern is that that I might not give competitors access to a certain input in a vertical transaction. The buyer and the commission might be worried that the buyer that is a supplier of an input that the target is the supplier of an important input that's useful to the competitors of the buyer in a downstream market. you can't really divest that upstream product, or you could, but that might seem a bit harsh. But the buyer might say, well, okay, well, what if we promise to just allow all third parties to have access to that input at certain prices and conditions over a certain amount of time? Shouldn't that address the concern? And oftentimes it does. So you do see behavioral remedies pretty often, and oftentimes they're quite complicated ones, but essentially that's what they are in vertical and conglomerate decisions. The Commission's practice on remedies is set out how it goes about assessing remedies and implementing them, is set out in something called the remedies notice. What it says is, talks about the types of commitments that the Commission will accept, what we just said on the previous slide, divestitures of a business, maybe severing of links with competitors, and different structures by which remedies might get implemented. We'll talk about those in a minute. Formally, there's a model text for divestiture remedies. So the divestiture commitments are, it's a document that explains this, a contractual type of document that has certain requirements, but it is standard text that the Commission doesn't want you to depart from unless there's a really good reason to do that. And it sets out the company's obligations. So it's going to describe the business and say exactly what you're going to do to sell it, let's say, how long do you have, and what's going to happen if this or that goes wrong. So quite a standard text that you'll see in published Commission decisions. Almost all divestiture remedies will follow something very close to what this model text looks like. And then Form RM is really more of the presentation of the remedy. So here's why, here's what the commitments are, and it's an explanation of why the commitments are suitable to address the concern that the Commission has raised. When you submit a remedy, you're going to submit both the formal commitments following that model text and a Form RM that explains why the Commission should accept the remedies. So this we've seen before. I think the interesting chunk here is really the small section, this statistic. So how many cases involve remedies is overall about 6%. That's since the merger regulation has come into force. That fluctuates from year to year, and people can sort of draw trends as to, remember the slide that we looked at, all the prohibition decisions, and you could sort of see waves. But the Commission's intervention rate is what we often call intervention rate, is cases that the Commission either blocks or requires remedies. 6% is the long-term average, but you can imagine if it's 4% versus 8%, that's a factor of 2 difference. So you can see different commissioners, for various reasons maybe, have had higher or lower intervention rates than others, but around 6% is the long-term average. And of those conditional approvals, you see here about 2/3 are in phase 1. So parties are really often going for that phase 1 commitments solution rather than going for the full investigation in phase 2 with statement of objections and the oral hearing and all of that. Usually the downside of phase 1 is the Commission will imply a higher standard to be really, really sure that these commitments address the problem and address the concern and are not going to be too hard to implement. So they need to be especially clear. That's kind of a downside from phase 1. You might have to, be a little bit more clear, a little bit more comprehensive in the remedies. At the end of phase 2, maybe there's some more wiggle room as to what exactly the remedies would need to contain. I say maybe. I'm not sure. I'm going to ask Michele what he thinks, whether there's really much of a difference between the standard that a remedy would need to, that commitments would need to meet in order to be acceptable at phase 1 versus phase 2.
I was going to come in. I think that the angle from which I would look at it is more perhaps at the end of phase 1, you have more concerns to address at the end of phase 2. So normally in complex cases where perhaps there may be many markets where at least at first sight there may be problems, the Commission may have at the end of phase 1, potentially after not too long a pre-notification, may have a broader set of preliminary concerns, which the companies will need to address entirely in order to get the transaction cleared in phase 1 and avoid the phase 2. So the perimeter of the remedy may be bigger in phase 1, while the phase 2 may, often does actually, allows the party to dispel a number of the concerns or rather of the serious doubts raised by the Commission in phase 1 and scope the case towards those concerns which are stronger. And so the perimeter of the remedy may have to be smaller. I don't think that if you look at structural remedies at the end of phase 1 or phase 2, the burden for the parties in terms of complexity and comprehensiveness is given the concern that the type of remedy has to will be particularly different. I think we are reluctant to accept behavioral remedies in phase 1 just because we like less and less behavioral remedies. So at the end of the day, we prefer to have a phase 2 and not have a remedy on the market than have perhaps a phase 1 with a complex behavioral remedy to implement. On structural ones, for me, it's more a question of perimeter of the remedy rather than of actual content once you have found the concern or serious doubt.
Right. Yeah, it's a really good point. So why, I mean, people might say that if phase 2 is such a torture, why would you do it if you know what's coming anyway? Well, you really might be hoping that you're going to narrow the issues. At the end of phase 1, the Commission only has to have serious doubts about an issue. At the end of phase 2, they really have to prove it to a level that has got to hold up in front of court, which we'll talk about later. And you may be hoping to narrow that, and that might, shrink the number of assets that you need to sell or something like that. So the phase 1 remedies you'll see are usually, not going to be really complicated. They're going to be fairly straightforward, usually involving the divestiture of a business that's a relatively standalone thing that the Commission can pretty easily see that's going to work, that's going to address the problem. Few general principles about remedies. Merging parties have to propose the commitments. The Commission will not tell you, I have a problem and this is what I need you to do in order to fix it. Sometimes that's fairly evident, other times it's not, but the Commission won't tell you what the remedy is. The burden is on the parties to propose a remedy, and then the Commission decides whether it's good enough or not. Commission will not say, I condition this clearance on this remedy. No, it doesn't work like that. The parties have to propose the remedies. At the same time, the commitments have to be proportional. The Commission can't extract excessive remedies, and there are cases, quite a lot of them actually, where the parties would put a remedy on the table and the Commission would market test it and decide, at the end of the day, we actually don't need you to do that. And there's a couple of cases on the screen where that happened. But my experience is, oftentimes the cynic might think, well, once I offer something, of course the Commission's gonna take it. And maybe there's something to that, but I think the Commission on their side have lots of cases where they can point to that say, look, parties have lots of times offered remedies that we ultimately decided were not necessary because there is this proportionality rule. I think the Commission respects it. Commitments have to eliminate the competition concern entirely. So the Commission is not going to accept a remedy that kind of fixes the concern. It doesn't necessarily have to eliminate the entire overlap, let's say, in a horizontal case, although it usually does, but it doesn't necessarily have to. It just has to address the concern. They're going to have to represent a permanent solution, or at least a very long-term one. in the case of behavioral commitments, which are kind of have to have a time limit on them, but it's going to have to last a long time, like a divestiture usually would. The commitments shouldn't raise in themselves any competition problems, and that might come in particular with respect to the buyer. So the commission won't approve commitments. Buyer approval is a separate issue, but won't approve commitments that look themselves like they're going to raise competition issues. You have to be able to implement them pretty fast. So if they look really, really complicated, having to move all sorts of pieces of businesses around and things like that, the commission is not going to like that very much, and shouldn't require too much additional monitoring. The commission appoints, and we'll talk about this in a minute, monitoring trustees to help them make sure that the parties are going along with what they said they were going to do. But if that's really intrusive, like, for example, again, suppose a behavioral commitment was, we won't raise prices for this product. Well, how is the commission going to monitor that? Well, I guess they'll have to have somebody retain a firm, or have the parties retain a firm to look at that. But that's going to mean what? Looking at every invoice that the company issues to make sure that the price is always the same, that it never raises prices. I mean, that all sounds like a big headache of the kind that Michele definitely doesn't want, and so he just won't accept that you have that kind of a remedy. Commitments are not the same thing as informal statements, which is not to say that informal statements are irrelevant. To get a conditional clearance decision will need to be based on formal commitments in line with the model text, et cetera, as I said before. But there are cases where the commission takes note of things that the parties have said or things that the parties are otherwise committed to do. That could maybe mean, for example, if the parties have agreed to do a remedy because of the process in another jurisdiction, the commission might take note of that and say, okay, we accept that that's what you're going to do, and therefore we don't need formal commitments saying the same thing. Similarly, even short of that, the commission might take note of things that companies have just said publicly that they're going to do. If there's reason to think that those public statements are going to prevent the companies from doing something otherwise, like Oracle Sun here. This was Oracle buying Sun, which was an open source database company, and Oracle said, we're going to keep it open source. The theory of harm would have been, we're going to take it in-house, we're going to remove the open source nature of the product, of the database product, and that's going to be a problem. And Oracle said, well, we're not going to do that. And the commission, in the circumstances of that market, thought that that was credible and took note of that in clearing the transaction. So that's not a formal commitment, but it was something that the parties said, that Oracle said they would do, and that was credible at the time.
Although that's very, very exceptional, I would say, I think, is you wouldn't see it in the most recent practice. I think what you would see perhaps in most recent cases is the commission taking note of agreements, which, for example, one of the parties have entered with a customer or a competitor, which to some extent could address some possible foreclosure concerns as one of the elements on which to potentially pose a clearance, but you will hardly ever see the commission clearing a merger only based on a factual element if it has real concerns. It's more as yet another element which may support the clearance in the absence of concerns.
Right. That's so. Suppose, just to expand on what Michele said there, suppose in a case there's a concern that the merging parties are going to restrict the supply of a particular product to a competitor, and suppose there's only one competitor that's relevant, say, and there's a sort of vertical theory of harm there. Suppose the parties come to the commission and say, well, look, we just entered into a 10-year supply agreement with that company for that product. That's the sort of thing the commission might take note of, right? That would should address the concern that the parties are going to cut off the supply of that product or jack up the price. That's the sort of thing that the commission might take note of. It's not a formal remedy. It's not a commitment to the commission, but it's something outside that formal process that addresses the concern. All that being said, those are exceptional cases. The commission has a strong preference for structural remedies. Usually that means, as we said, divestitures. Maybe in vertical and conglomerate cases, behavioral commitments are still viable. I think they are. But especially in horizontal cases, it's usually structural remedies that we're talking about. There are some cases where it's just all too complicated or too hard to fashion a remedy. And because it's the party's responsibility to propose an effective remedy, the answer in those cases is sorry, but you just can't do your deal. We're gonna prohibit it. And by the way, I'm purposely going quite a bit quicker through the slides now because we wanted to go shorter on these sections. So don't panic if I'm going too fast, but still don't hesitate to ask questions.
Chris, can I ask you a question? Have you
Yeah.
seen? I mean, have you seen now in the recent of the practice by other agencies, being the CMA in the UK or the new management of the Department of Justice of the FTC in the US, a shift in their approach to remedies, as they're requiring more structural solution also in non-horizontal cases? How do you assess the dynamic between agencies beyond the commission on the issue of remedy recently?
I think it's an interesting question. I think it's worth reflecting on whether the commission might actually be or have been more receptive to behavioral commitments than those other agencies have become. Your thoughts on that are probably of more validity than mine, but yeah, I think, I mean, and some of these agencies have actually made comments that suggested to me that they thought the commission was being too lenient by accepting behavioral remedies in some cases. I don't, personally think that's so, but indeed, other leading agencies around the world, some other leading agencies around the world have suggested even more skepticism toward behavioral remedies than I think the commission has shown. Does that answer your question, Michele?
Oh, thank you.
Okay, so structural remedies, the usual situation. So again, this is usually involving the sale of a business or part of a business. Usually pretty straightforward. I mean, you would think, but oftentimes when you get into the facts, there's a lot of complicated stuff. Basically, what you're trying to do is fashion a business that's a going concern that includes all the stuff, all the people, all the assets, all the contracts that the buyer would need. So suppose, Till is going to show up and buy this business and he's got all he needs to keep it running tomorrow. That's the premise that the commission starts from. So again, people, all your contracts, all your licenses, supply agreements, all this stuff. And the commission is going to just make sure that it's a viable, basically standalone business. And that's the way they're going to approach a remedy discussion. It might be that when a buyer comes along and says, well, I don't really need all these people because I'm going to integrate this business with my own and I already have a sales force. So I don't need all the salespeople from the business. Then the commission can say, okay, I get it. You don't have to take them. We don't want to saddle you with the costs of those people or those assets or some assets that the buyer doesn't need. But you pretty much have to start off with a viable business that could really be a turnkey kind of business, includes all the assets. And there's going to be a lot of scrutiny on that when you're discussing the remedies with the commission. So again, the commission prefers a standalone business that already exists. You don't always have that, but you kind of are expected to come up with one, and that may even including assets or parts of the business that are not really the concern of the commission. You might have to, if you can't really carve out a little piece of a business that precisely addresses the market where the commission has concerns, you might have to just include a broader business that includes more stuff that really isn't a competitive concern, but it's about the viability of the divestment business. Something called a reverse carve out. So suppose you've got a factory that makes 3 products, of which two are the concern. What the commission would probably want the seller to do is sell the whole plant to the buyer. And if there's stuff you want to take out of it and take it back to yourself, maybe you can do that if the plant is still going to be viable, rather than say, well, I'm going to keep the plant and just move a bunch of machinery out to the buyer. The commission will think that's more risky, probably going to jeopardize the viability of the divestiture. They'll rather have you sell the whole factory and then take back what you want. They call that a reverse carve out. Asset divestitures are possible. IP rights, depends on what the competitive concern is. So divestitures are often really big transactions of their own. Holcim Lafarge, a big cement company merger. The parties agreed to sell basically one or the other party's entire business in every EU country. And I think in this transaction, the divestment business was valued at something like 7 billion euros. So sometimes the divestment businesses are themselves huge transactions. Ball Rexam, this aluminum can manufacturing merger, phase 2 divestiture. Again, you see there what was the remedy? 10 plants or 12 plants really were sold. So that was the parties really trying to put together a big enough package of assets that would make a standalone business that would be large enough to have a viable share of the market, et cetera, and be able to be cost competitive. Similar story, beer merger, AB InBev, SABMiller, a case that was cleared by the commission, subject to remedies, but arguably somewhat of a Pyrrhic victory for the merging parties, because they basically had to divest SABMiller's entire EU beer business. So this was a global merger. If it was a European one only, it would have been prohibited. It was a global transaction. There were other stuff that AB InBev wanted to buy, but to get the commission's approval, they basically had to divest all of the target's business in Europe. I'm gonna skip that one. Crown jewel. This is a term you see in remedies discussions sometimes. Again, suppose we've got a horizontal overlap in a product that's made in a factory. And the buyer has a factory and the target has a factory that makes the same product. And the horizontal overlap would be eliminated by selling either one factory or the other. And the buyer says, well, my factory is a nice big new one and the target's is a kind of old scruffy one, and I'd really rather sell that. And that would eliminate the horizontal overlap. It would would eliminate the concern. What the commission might say is, okay, you can try and sell the target's old scruffy plant, but if you can't do that within a certain amount of time, what's going to happen is you're going to have to sell your own. That's a crown jewel. So that really motivate the buyer to try and get that other factory sold. So it's kind of that's a carrot and stick motivation. That's the stick, is the crown jewel. If you don't get don't get away with selling the small business in a certain amount of time, you're going to have to sell the big one. Michele, anything, comments on such?
No, I think the only two comments that also to tie into what you explained before on pre-notification and phase one remedies, both the SAB Miller transaction and Osim Lafarge that Chris highlighted before as two transactions involving very large overlaps in Europe and also very large remedy packages as a result of the competition assessment, were both phase one clearances, where so the Commission did not have to go into phase two because the parties front-loaded in pre-notification not only the assessment of the transaction, but also the remedy discussion. And there was essentially, at the time of notification, so when the file was ripe for the process to start, the two packages were also ready for being tested with the market. And so just examples of a party strategy of avoiding what would have been a more likely, in all likelihood, a phase two, absent those remedies, and trying to have a fairly sizable package already getting pre-notification, with a possible downside highlighted by Chris, that maybe the package was very large, entailed the entire overlap, and maybe could have been a bit smaller had it been at the end of phase two, but the party chose speed over size, if you want, of the package on those ones.
Right. So next topic is approval of suitable purchasers. There are purchaser requirements, and not to pick on Till, but Till is probably not a suitable purchaser for a factory that produces aluminum cans. Even if he has lots of money in his wallet, I don't think he's an expert in that business. He doesn't have experience. He probably doesn't really know how to run the business. And so the Commission is very, very careful to ensure that whoever is going to buy this business that you're going to divest actually knows what they're doing with it, and they're not going to fly the airplane into the side of a mountain. So they have to be independent of the merging parties. You can't sell it to your brother-in-law. You have to have enough money, and you have to know what you're doing. You have to have some experience in the business, oftentimes quite specific experience in the business, and the transaction can't raise any competition concerns of its own on the face of it. So when you narrow that all down, in concentrated industries, sometimes this becomes a problem because there might not be all that many firms that know about a business enough that the Commission can be sure that they know what they're doing, that they're not going to make a mess of the divestment business. But if there aren't that many, then maybe several of them are going to have themselves competition problems in buying that business. And so this can be kind of a complicated thing to think through, finding suitable buyers for when the merging parties want to get rid of a business. It can be pretty complicated. Let's see. So when the Commission is going through this, they're going to have a certain amount of time to, the parties are going to have a certain amount of time, we'll come to this in a moment, to get that divestiture done. And there are a couple of different structures by which the Commission gets additional assurance that that the divestiture is going to be implemented in a timely way. This is just an example of a case where the Commission rejected a proposed purchaser of motorway service stations because they thought that the buyer that was proposed at first didn't really have enough experience and wasn't really sure, didn't have experience to know how to operate those stations, and it was going to be too small, so they weren't sure that was going to work very well. One of the structures, and the more common one that the Commission uses to make sure that a divestiture gets implemented in a timely way, is called upfront buyer. And if the Commission is not really confident that the parties are going to have an easy time finding a good, suitable buyer for a business, they might impose this requirement. And what this means is that the merging parties are not going to be allowed to close their deal, the primary deal, until they have found a suitable buyer that's been approved by the commission. So that's, obviously there's always a lot of pressure to close the main merger transaction. And this comes along and it says, now you have to figure out who you have to fashion your divestiture and find an approved buyer before you can close. It puts a lot of pressure on the merging parties to do the remedy fast. And this is just a couple of examples of cases where the commission did impose upfront buyer remedies. There are a lot more, as I'll come to in a moment. An alternative, even a little bit more dramatic, I'll ask Michele what he thinks about this in a moment, is called a fix-it-first remedy. This is similar to the upfront buyer remedy, except it's even more front-loaded in that the commission's decision approving the notified merger already includes an approval of the divestiture and the buyer. So you've got not only the remedies package, which is always a part of the commission clearance decision, but you've also got the purchaser approval in the commission's clearance decision. These are quite rare. I think not because the commission doesn't like them, but I'm going to ask Michele for his view. I think not because the commission doesn't like fix it first, but just because it gets to be really challenging to do all of this stuff within the phase 2 or much less phase 1 timetable. There's just too much stuff on the commission's plate, purchaser approval on top of all the other stuff they have to do within the deadline in order to get the clearance decision issued. And so you see, I think upfront buyer cases or even sort of hybrid cases where the commission might kind of take note and give a wink and a nod to a buyer that the parties have in mind by the time of its clearance decision. But the purchaser approval comes as a separate decision later, not in the merger clearance decision under the fix-it-first structure.
I think I agree with what Chris said. I think upfront buyers are becoming increasingly common, not least because in the recent years we've experienced complexities. The pandemic may be a reason, but not the only reason in implementing more traditional divestiture remedies even. That is to say, remedies where the commission had approved a transaction subject to structural solution, divestiture, sales of assets, without an upfront buyer transaction, so that the main transaction could close and the remedy transaction was dragging along for a long, long time. Of course, we don't know the reason for that, but we had happened to have a few instances where that was the case, which is pushing us even more to require or request the parties to offer an upfront buyer solution quite often, because as Chris explained, an upfront buyer solution puts a lot of pressure on the merging parties to find a buyer for the remedy assets, because unless and until the buyer is approved, the parties cannot close the main transaction. I also agree with Chris again on the fact that fix-it-first solutions are rare. And I think the reason is precisely because in complex deals, the perimeter of the remedy is agreed very late in the process, which essentially leaves no time for the parties to actually conduct a proper sales process for the remedy, find the buyer, sign the SPA, have the commission approve the SPA in the term of the within the deadline of the phase 2 merger investigation. We had a few telecoms case in Italy a few years ago where we had that, but it's really, really rare. Is rare, but less rare, the hybrid solution that Chris hinted to. I think in G. Alstom, which is a merger case we had also a few years ago concerning gas turbines. There we had an example of a hybrid solution whereby during the phase 2 process, we identified a package together with GE, which consists essentially of divestiture, amongst others, of certain type of turbines by Alstom. But we were also faced with a very concentrated market, as also Chris mentioned before, and essentially we could only think about one possible buyer for these assets. And so what essentially GE did during the process is to essentially negotiate with his buyer, together with the buyer, give the commission some comfort that the buyer was interested and that the key parameters of a deal with the buyer were in place. So the commission took note of that in the decision clearing the merger, by essentially also arguing why the remedy was sellable by reference to the fact that there was a tentative deal in place with the company Ansaldo, which would have bought the assets. But then after the clearance decision, which was upfront in any event, there was a separate commission decision approving the buyer and the terms of the deal, just because it would not be possible to do so in the time of the phase 2 investigation.
Yeah. So this case, Inco Falconbridge from several years ago, it's just an example of one where there was a fix-it-first remedy. The commission was doubtful that there would be buyers who would be suitable, and the merging parties actually found a suitable purchaser and agreed a deal, and persuaded the commission that the buyer was a good one during the review process. So that's a rare example of a fix-it-first case. But you see, as Michele said, these are becoming more common, and that might be because his boss likes them more. But you see, for a long time, you know, it was maybe 10% of European cases where remedies were fix-it-first, or most of these are upfront buyer remedies, and but that kind of closely corresponding to Commissioner Vestager's arrival on the scene jumped up to about more like 30%, and last year even up to 50%. So definitely this is becoming a more common requirement. I mean, why wouldn't you have a fix-it-first remedy? Well, it's preventing the parties from closing the transaction, right? It's delaying the closing of a transaction that the commission has concluded is not going to significantly impede competition because the remedies are already agreed. And if the assets or if the business to be sold is standalone, if the commission is pretty confident that there are going to be several qualified, interested purchasers, which the commission is in position to verify, then there's no good reason to hold up the closing of the big transaction. But if there are doubts about the identity, the interest of purchasers, or if they think if the assets are complicated, if it's not sure that the business is really going to work, mainly, I think most often is whether there will be interested buyers, then that's going to result in this upfront buyer remedy. Michele, I think that you agree with that?
I do.
This is the same, mostly the same numbers, the same yellow line at least, in showing the breakdown between phase 1 and phase 2. But you see, especially in 2020, the proportion of phase 1 cases that involved upfront buyers went way up. And again, that's, I think, maybe because in phase 1 there's just less time to go through all the details and for the commission to really satisfy itself that there are lots of interested third parties. And so, you know, it's kind of a safety valve really for the commission to put pressure on the merging parties to make sure that they can and do focus on getting their divestiture done ASAP. So I wouldn't quite say the new normal, but half of cases now are going to have that kind of a condition imposed. This decisions imposing restorative measures, I'm going to skip it unless Michele wants to talk about it.
No, we can skip it.
Not very often the case in merger cases because this is really if something has already been implemented and the commission then prohibits a transaction, so usually in connection with maybe one of those public bid scenarios like we talked about earlier, and the commission is going to have to, in addition to prohibiting a concentration, take other decisions to kind of reverse things that have already been done. Another type of remedy that's fairly common in some circumstances is severing links with competitors. And what can this mean? A few different things. So maybe suppose a concern is that one of the parties has a minority shareholding in another company that gives it some influence but not control. It's not part of the same undertaking. A remedy might be, okay, well, we'll divest that minority shareholding. Or a party is involved in a joint venture with another company. You might get out of the joint venture, similar reasons. You're worried about not control and not part of the same undertaking, but links with competitors that pose concern. Cutting agreements with competitors or withdrawing from alliances. This is actually a really common remedy in shipping liner cases, which their shipping companies often have consortia, and the way the commission analyzes those is that kind of attribute market shares of consortia all to the merging parties, and which dramatically expands the amount of market presence that the individual shipping company has. And so a pretty common remedy in a bunch of these cases is that one of the parties agrees to end its participation in a consortium. So I'm not going to cooperate with all those other guys anymore. I'll just stand on my own with the merging party. And this case is just an example of severing links with a third party in order to obtain approval of a transaction. So non-structural remedies. Again, this has evolved over time, and it may be continuing to evolve. It's a very much a live subject, as Michele and I were talking about earlier on. But back in the GenCore case, the court said that the commission is allowed to accept behavioral undertakings, and there are lots of cases where the commission has done. We talked earlier that the commission prefers structural remedies, but in especially vertical and conglomerate cases, behavioral remedies might do the trick. So Tetra Laval Cedel is one of the cases that the commission blocked in the early 2000s and the general court overturned. The commission in its decision had rejected, this was a conglomerate case where the concern was that Tetra Laval, the maker of Tetra Pak cases, was going to kind of bundle Cedel products, which was PET packaging. So it was a conglomerate case, and the concern was that the parties were going to bundle those two things. And Tetra Laval said, I won't do that. So a behavioral commitment, I won't bundle those two products together. And they also pointed out that, well, even if I did that, wouldn't that in itself be a violation of Article 102? It would be abusive of me, my dominant position as a packaging container manufacturer, to bundle those products with these PET bottle containers. And on appeal, so the commission blocked the transaction. And on appeal, the general court said, no, the commission, you should have paid attention to those, notwithstanding that you don't like behavioral remedies very much, because you had to consider that Tetra Laval, did say, we're not going to do that kind of bundling that you're worried about. And by the way, it would also violate Article 102 quite probably if we did what you are worried about doing. Don't you have to take that into account too, in considering the likelihood that we're actually going to do that? The courts agreed with the merging parties on that one.
I think perhaps if one area where the discussion on behavioral remedies and the adequacy of these remedies to address concerns is particularly live these days is the digital world, where it is often hard to find structural solutions because most of the combination we've seen so far are conglomerate in nature or vertical. Think about the Google Fitbit, which Nick mentioned, Chris mentioned at the beginning of the class, where essentially Google, that we know what it does, was acquiring Fitbit, the maker of smartwatches, and in a transaction would have combined, if you want, the Google domains, Android, together with a hardware maker of wearables and the data it collected. There again, it was very hard to think about what one of the other company could have divested to address that concern, because again, if you divest Fitbit, you don't do the transaction. On the Google side, unclear what the divestiture could have been. And so oftentimes, but that is the same for in Microsoft LinkedIn we had in the past, and in other tech transactions, where oftentimes an agency will be called to either block a merger, assuming it finds concerns, of course, either block a transaction on the ground that essentially is very hard to accept and monitor behavioral remedies in this world, or try to devise as comprehensive and adequate as possible behavioral solutions to address the concerns that one may have identified. So far, we have done that. So in a few tech transactions where we had concerns, last one precisely being Google Fitbit, we have approved the transaction subject to behavioral solutions. The Google Fitbit, the two most notable examples consisted of, on the one end, Google committing to a data silo remedy whereby it would not have used any of the health or personal data gathered through Fitbit for advertising purposes. So no data combination, if you want, between the Fitbit data world and the Google world. Still quasi-structural, because again, it was a whole separate, but still behavioral, because not a divestiture. And on the other end, a more traditional opening of an interface so that Fitbit competitors could continue to have access to the Android operating system and would not be essentially damaged, because Fitbit would have a preferential access to Android, and so could not be foreclosed from the market from wearables, where, by the way, Fitbit had a 5% market share pretty much. Still behavioral solutions, and we were criticized by a number of commentators and stakeholders and agencies because of that. And again, the debate is a live debate, is out there. The other authorities have taken a tougher stance. Take the CMA, who was recently blocked in the UK, was recently blocked the Facebook Giphy merger. Also in the tech world, the acquisition by Facebook of a small startup like Giphy. If you read statements by top US officials, FTC and DOJ, they also seem to be quite wary of vertical or of behavioral remedies in tech mergers. So that's, to me, the area where now the debate of behavioral versus of the adequacy of behavioral remedies is most live and will continue to be live for some time.
Right, absolutely. I think that the leading case on that debate about whether behavioral remedies are appropriate is definitely Google Fitbit. Another one that might be a little bit simpler to illustrate what the remedy was is Microsoft LinkedIn. So the concern was that Microsoft was going to use its Windows dominant position in Windows to strengthen LinkedIn's position vis-a-vis other professional social networks by doing things like pre-installing LinkedIn in Windows or kind of integrating it with Office or other things similar to that. And what Microsoft committed to do was basically not to do any of those sorts of things. So allow computer manufacturers not to install LinkedIn on Windows PCs if they didn't want to let users remove it if they don't want it, and to let competitors use the Office suite in the same way that they did before, so as not to preference LinkedIn. So that's an example, a fairly simple example of the kind of behavioral remedies that may very well work in a vertical or a conglomerate type of case. Just a couple more slides on remedies. Modification of commitments. I think the short answer here is yes, you can do it if you have a really good reason, but you're going to need a really good reason. One example of that being this one, Takeda Shire. So this was a pharmaceutical merger that was approved subject to the commitment to divest a Shire pipeline drug, so a drug that they were developing that was going to compete with an existing Takeda drug. And so the commission was worried that after the merger, Takeda wouldn't continue investing in that development program because the new drug was going to compete against Takeda's existing drug. And so they required Takeda to divest that pipeline product, so the R&D program and all the data, et cetera. And they were trying to do that, but struggling quite a bit, partly because during that time, it emerged that there were a bunch of other new drugs that were kind of on the market and were going to be better than the Shire pipeline drug. They did some trials, and the Shire pipeline drug didn't come out very well in them. And they were trying to do patient trials, and they couldn't even find patients to get the clinical studies done. And so basically, this product that they had been promised to divest was really becoming less and less strategically important. And Takeda ultimately persuaded the commission that this was not a competitive concern anymore. And also, by the way, we really can't sell, like no one wants to buy this project and continue it. So the commission allowed the commitment to be dropped. Implementation, so very quickly for divestitures, the way the structure works under the model text is you have what's called a first divestiture period. This is not with an upfront buyer remedy. You have a first divestiture period, it's usually 6 months to sell the divestment business. And if you don't do that, there is the nuclear option, which is you have to give the business to what's called a divestiture trustee, who is then empowered to sell it for you at no minimum price. So you really don't want that to happen. It's a big stick to get your transaction done in the first 6 months when it's under your own control. I don't know, Michele, offhand, if there ever has been a case that's gone to a divestiture trustee. Actually, I think there might have been 1 or 2, but it's extremely rare.
I recall one back in the days where it was Universal EMI, where a very small part of the package was sold to a trustee, but to the registered trustee, but as you say, it's very rare.
Exceedingly rare, just because the merging parties are always going to think they're better able to sell a business than giving it to somebody who's empowered to sell it at no minimum price. So what do you do? The deal closes. Now you have to sell this business. What do you do with the business? It hands over to the control. You have to hold it separate from the rest of the company, right? You can't sort of take it, start taking all the data, talking to the people, integrating it. You're going to have to sell it. And so you transfer the business. You keep it under the management of what's called a hold separate manager. during the time until you sell it. The hold separate manager is very often the boss of the business as it exists. And the hold separate manager reports to a monitoring trustee who makes sure that the parties are taking all the steps to sell the business as quickly as they can. They're not acquiring information from it. They're severing the IT systems, all that kind of stuff. So the business gets held separate from the merging parties or merged parties until it's sold. As I said, monitoring trustee is appointed to watch over this. These are professional firms that do this. That's what they do. And it's usually banks or accounting firms, that sometimes law firms that do this kind of business. But this is a specialized role. Monitoring trustee people do this for their job, and what they're doing is essentially acting as the commission's eyes to make sure that the divestiture and the associated obligations with that are being carried out as they're supposed to. So they meet with the divestment business, they meet with the parties who are doing the divestiture, they make reports for the commission, they talk to the commission, just to help the commission make sure everything is going according to plan. Remedies for breach of commitments are not very often implemented, because most of the time commitments get implemented as they're supposed to. But there have been a couple of cases. The commission hasn't revoked a clearance decision for breaching a commitment. They've come close a couple of times. Most recently, a Telefonica Deutschland case where the commission actually issued a statement of objections relating to the conditions under which Telefonica Deutschland had granted network access to third parties in Telecom's case, but the commission ultimately decided that it wasn't all that bad as had been complained about, and dropped that case. But the commission is empowered to impose fines or indeed revoke a clearance decision if the third parties don't do what they've committed to do. That's our remedies discussion. Let's take a 1-minute pause and then talk about judicial review for about 15 minutes. Thank you. Let's take a 20-second pause. So judicial review, merger decisions are appealable, as we've seen, to the General Court, to the European courts. There are all sorts of commission decisions, specific types of commission decisions are appealable, but appeals don't happen very often in the merger context. Why? Well, usually they're clearance decisions. There are 8,000 merger decisions or whatever. 7,100, I think, is an old number. Usually they're clearance decisions. The merging parties aren't going to appeal a clearance decision. There are 30 prohibition decisions. Merging parties might want to appeal a prohibition decision, but they might even not. Why? Because, well, as a commercial matter, they can't hold a deal together for years and years that's going to take to run through an appeal process. So oftentimes, even prohibition decisions don't get appealed just because there's no use. There's no even if you were to win the appeal, you probably can't salvage the transaction that got prohibited. But so that narrow range of decisions, they are important. And this is actually, I think, a bit of a shortcoming of merger control law in Europe, is that there aren't that many court decisions, but the ones that there are important sources of law on a lot of different issues, as the slide says, on things like standard of proof, burden of proof, evidentiary issues, the substantive test. They are really important. And Michele, I think the main topic that I would like to cover in this next 10 minutes or so revolves around your perspective on how the prospect of judicial review shapes the commission's thinking and decisions during merger reviews.
Yeah, maybe I can give you a quick perspective from the commission side. I think I agree with Chris that there are not many cases out there of jurisprudence on mergers, but the ones that are out there are quite important. There will be more coming. I think we have a few pending cases before the court, a couple of clearances being appealed. The Vodafone Liberty Global in Germany being the most notable, a couple of provisions being appealed, the provision of the Tata ThyssenKrupp merger being the most relevant one. We have our own appeal to the Court of Justice of the General Court's judgment that you see last in the slide here to the right, the Telefonica, the H3G Telefonica merger, which we blocked in 2016. Our provision was annulled on the substance by the court last year, the year before by now, and we have appealed that annulment to the Court of Justice, and that's expected to be a very important judgment on the substance of the hardcore legal test of the merger regulation on the interpretation of what is a significant impediment for affecting competition. So I think there's more to come. Hopefully there will be more interesting judgments coming up in the merger control world in the next year or so. But I mean, to answer Chris' question, it very much influences the thinking of the commission, in particular in borderline cases. And it does it in two ways. On the one hand, the commission doesn't really want to lose cases in court because you're still an independent administration which should apply the law, and so you want to apply it in the best possible way, so you really don't want to lose cases. On the other hand, bringing cases and pushing the boundaries of some aspects of the law is also part of the duties of a competition authority. So there is somehow this double push or pull. On the one hand, you have to be conservative, apply the law, and make sure that you do things which are sound and reasonable. On the other hand, you're also your duty to push the boundaries when you think that the law as it stands is not fully in line with in sync with the times and with the new issues. So I think as you know, the commission decision-making process is one which involves different stakeholders, which all have a say, in particular towards the end of a complex phase 2 process when these considerations start coming into play. So when essentially you have to take the view as to whether a merger can be blocked or should be authorized based on the possible remedies that we discussed before. And there you have the stakeholders being the case team, being our legal service, who in the end is the commission service who goes and litigate our cases in court and has to give an advice as to whether the proposed course of action is sound, is legally sound. And of course, the commissioner and the chief economist. And the legal considerations and the litigation risk, or rather the risk of losing litigation, is and the probabilities of winning a case in court are certainly an important element of a decision to go for a provision, which normally is the type of decision which is most likely challenged before the court. I mean, there are some clearances that are challenged, but essentially the ones which really push the boundaries of the law and where the commission is more exposed are provision decisions.
Yeah, it's really interesting that it's in a sense, I think, to a large extent, self-discipline on the commission's part, because as I said, the merging parties, the most likely appellants of a prohibition decision, may not be highly motivated even to appeal when a deal gets blocked. And so I think the commission kind of doesn't want to look bad when they lose, but probably the deal is not going to be resuscitated anyway, which in a sense kind of lowers the stakes. I saw recently I think it was the new chair of the FTC, Lena Khan said something to the effect of, well, if we don't lose in court sometimes, then we're not doing our job, which is a little bit different approach than what Michele just outlined, more conservative. So we'll see how that goes over the next few years internationally. So what can you appeal? Very quickly, you can appeal decisions that produce legal effects. So that means, clearing a decision. If a third party is directly affected by that clearance decision, the third party, like a complainant, can appeal. Or prohibition, obviously, that affects the interests of the has effects on the merging parties, so that can be appealed. But measures that don't produce legal effects may not be appealed. So you can't just appeal anything that the commission does that you don't like say, this information request is too burdensome or something like that. You can't appeal that to the court. Or parts of a decision, a clearance decision, say that don't have legal effect. You can't appeal that if you don't like the way something is written, like on the market definition in a decision or something like that. You can't appeal that. It's got to have legal effect. I'm going to skip that one. So this is an example of what I was just saying in Coca-Cola. So this was a deal that was unconditionally approved, but Coca-Cola appealed the decision because they didn't like the commission's finding that the Coca-Cola company, the company that makes syrup, controlled Coca-Cola Enterprises, which is its bottler. There was some corporate links between the two, but it was sort of an unclear situation. And for various reasons, Coca-Cola Company did not want to be held to control Coca-Cola Enterprises. The commission said in its clearance decision, you do control them. The Coca-Cola Company didn't like that and appealed. But the general court said, no, you can't appeal that because it's not an operative part of the clearance decision. So who can appeal? Who can institute proceedings? You have to have an interest in the procedure. This is pretty self-explanatory. The merging parties, obviously, but also third parties, like even member states, can appeal decisions. They don't do that very often, but once in a while. Merging parties, almost always. Competitors might be able to appeal, usually if they've really been involved in the process, if they've been invested in the commission's review process and the merger, they can show that the merger being approved has a direct effect on them, then they may be given standing to appeal. Probably what you would think. Employees can appeal. I haven't seen this very often. But you might have like trade unions or things like that appealing a decision if they think that it would bring redundancies. And that was attempted once in Nestle Perrier case, at least once, and General Court found no, that wasn't admissible because the commission's decision didn't directly affect the legal rights of the employees. Standard of review. Well, we can cover this quickly, and this will be about all. So the general court's review is essentially, actually, Michele, why don't you cover this one? I'm curious as to your thoughts on how this works in practice.
Yeah. So I think that in principle, what the treaty says is that the European courts can, of course, the Commission decision can be appealed to the European courts. And the General Court, in first instance, has to make sure that the commissions did not commit any manifest or assessment of the facts, that the reasoning is sound, that there is compliance with the rule of procedure, that the statements are adequately motivated, and that it did not misuse its powers. What, in theory, the court cannot do is substitute its own assessment to the one of the commission. That is to say, in theory, the court should limit itself to check whether what the commission has done is in line with what I just said before, but not redo the case itself, not redo the assessment itself, while, of course, looking very closely at what the commission has done. What happens in practice is that it really depends so far on the chamber of the court that you get. Some parts of some chambers of the court are very deferent to the commission. Others tend to be increasingly so a bit less. So you happen to have decisions or judgments of the general court where the court essentially often tends to really redo a bit the assessment of the commission and exercise a very deep judicial review, which is not bad in itself. It's just a feature of how the system has evolved over time. And so that you have two layers of review. You have general court, which has the type of scrutiny and standard of review which we just discussed. While if you lose at the general court, you can go to the Court of Justice, but only on matters of law, not on matter of fact. So the facts are definitely established by the general court. You can only bring legal questions and legal issues to the highest court, the Court of Justice. And then we can maybe
So,
to this.
Right. So did I understand well that, you think that in practice, the general court is not very much constrained on what it can review of commission decisions?
It really depends. I think it depends on the chamber you get. But you have examples of the Court of General Court being very deferent to the commission, and others of the General Court going in a very close factual examination of what the commission has done. So I think it varies quite a bit.
Consequences of annulment. This is, again, not a big surprise, but suppose a commission clearance decision was annulled. What are you going to do? Well, the commission is going to have to look at the transaction again. And they're going to do that according to the merger regulation in light of the current market conditions. This hasn't happened very many times, but it has happened a few times or a couple of times. Sony BMG Impala being maybe the main example. The commission cleared the transaction. The general court overturned the clearance decision on appeal by a third party. And then the case went back to the commission again for a re-review. And the commission, in its second review, did take account of market developments that had happened since the first review. There's a possibility of seeking damages against the commission, not under the EU merger regulation, but under TFEU. If the conduct was unlawful, you suffered actual damage, and there's a causal link between the conduct and the damage. But this is real hard to prove. It's happened a few times. Schneider-Legrand is a case that we've talked about several times today. After the general court overturned the commission's prohibition decision in that case, Schneider sued the commission for damages. You remember they had previously acquired those Legrand shares and had to sell them at a big loss, and in particular, that's what they tried to recover from the commission. The general court on that one said no, because basically Schneider, in acquiring those shares, they said you sort of presumed that the merger would be approved, and you were wrong about that, so that was kind of your fault. And lost opportunity. The court also said no to that. But costs, small potatoes really, but yes, the court allowed Schneider to recover the costs that it had incurred by appealing the commission's decision. And then I think the last thing we'll talk about is just that there is such a thing. We talked about the shortcomings of the court review process and how appeal is often not an effective remedy for merging parties who have had their deal blocked. There's an expedited procedure at the court. Yes, it helps. It's a little bit abbreviated. There's less back and forth in writing. It's a simplified procedure. It still takes marginally around a year, say, which is itself a pretty long time for a transaction that's been blocked to be in limbo, and the prospects of success on appeal being probably not that great. It's quicker than the normal procedure, which takes 2-3 years at least. So the expedited procedure does help, but it's still not really giving the merging parties a very effective recourse for a deal that's being blocked. And then, as Michele said, there are appeals from the General Court to the Court of Justice, but here I think the limitation on what the Court of Justice is going to look at is actually more of a restriction on what the court can do. Appeals here are limited to points of law, as Michele said. The Court of Justice is not going to get into the facts and the economics. So I think that's our deck. We're just about on time. Let's take another 15-minute pause and come back for a final few minutes with Q&A with Michele.
Hi, Nick. Welcome. I've seen you, but I just want to try if your microphone is working.
Yeah, can you hear me okay?
Yeah, we can hear you.
All right, excellent, excellent.
Thank you. We'll start in 7 minutes if that's, well, 6 now, if that's fine for you.
Perfect.
Okay. Thank you. Yeah, hi, we are back in the room. Everyone on Zoom is there too. I let you start. The floor is yours.
Sorry, let me
starting, me
unmute
or Nick?
myself. This is Nick.
There's Nick.
Very nice to see you all again. Sorry not to be with you in person. I'm sure you've had a extremely interesting session this afternoon with Chris and Michele. We thought we'd finish today with a few questions to Michele, whom, as you've heard, is Commissioner Vestager's Chief Advisor on merger matters and has a long and deep experience in this area of the law. I'd like to pick up on where I imagine you left off, hearing about judicial review from Chris. Over 30 years, Michele, the courts have played a very important role, I'm sure you'd agree, in confirming some issues concerning the scope of the merger regulation, clarifying others, possibly provoking the Commission to introduce checks and balances that I think everyone would consider has served the process well after the trilogy of judgments in the early 2000s. The most recent judgment of note, as you know, is the 302 judgment overturning one of Commissioner Vestager's first landmark prohibition decisions challenging a 4-3 merger in the telecom sector. And as some of the students will know, her predecessor had approved some mergers in that sector of a broadly similar kind. That judgment is under appeal to the Court of Justice, as you know well, Michele. What's your perspective on the General Court's judgment and the implications of it for the standard that the Commission must discharge? We spoke during my session, I'm sure Chris touched on it too, about this debate as to whether the standard is a balance of probability standard or a beyond reasonable doubt standard. And the court seems to go further than people have thought in suggesting that the standard may be higher than balance of probability. First part of my question. And the second part of my question is, many had understood the guidelines instituted when substantive tests changed in the early 2000s to a significant impediment to effective competition test as making it easier for the Commission to challenge unilateral effects cases. But the court seems to make it that bit harder than many of us thought. So what's your thought, Michele, on the implications of the judgment?
Thanks for the question, also because it's a case which is very dear to my heart, having been the person in charge of the prohibition decision in the Commission. So I think I followed the follow-up to that with a lot of interest. We thought we had a good case when we blocked the merger, otherwise we would not have done it. We thought we had a strong case on the substance, that the interpretation of substantive impediment to affecting competition that we gave in the decision, including from the angle of clauses of competition, important competitive constraint, important competitive force. We thought that the interpretation we gave to those notions, which are in the horizontal merger guidelines, was the right one and was sufficiently supported by the effects of the case. Interestingly, we thought that the potentially trickier part of the challenge would have been on remedies, because the parties had offered remedies that we had accepted in previous cases to offset the concerns. But the court didn't even get to that. The General Court annulled us on the finding of SIEC, so it didn't even have to look at the issue of remedy. We, of course, took note of the court's judgment. We respectfully disagree with a lot of it, in particular with the legal interpretation that the court gives to a number of concepts of the decision and by reference to the horizontal merger guidelines. And of course, we'll have to see what the Court of Justice will say. Whatever it will say, it will be a very important judgment on the interpretation of the 2004 amendment of the merger regulation and the notion of SIC, of closeness of competition, or important competitive constraint, important competitive force. And so again, we all look forward to that, also because in the meantime, we are left a bit in a limbo, in the sense that we still take the view that our interpretation is the right one, but of course there is a general court judgment which says the opposite. And so we'll have to see also, we haven't had yet a specific case in which we had to take a decision on what to do, but it's certainly something which I think would be good if it is clarified as soon as possible. And we see, I think it's probably one of those judgments of similar systemic importance as your Impala saga, Nick, because that essentially set a bit the scene for the interpretation of coordinated effects. While here we think that whatever will come out of the Court of Justice judgment here will really have a fairly strong word on how the notion of SIC will have to be interpreted going forward.
No, that seems to me right, Michele. I mean, after all, this was a situation where you had existing competitors. And so there was quite a bit of evidence as to the extent to which they were competing and whether they were close to each other. As you know well, one of the big debates over the last few years has been whether the merger regulation is fit for purpose for challenging acquisitions of relatively small but potentially important players, particularly in the digital and the pharma sector. And I'll get to the questions around the jurisdictional scope of the merger regulation in a second. But it seems to me the judgment is also interesting in respect of the substantive assessment of those transactions, because recognizing merger control is a predictive exercise where you're looking at an acquisition by an incumbent company, however strong, of a relatively small player in the market, being able to prove to the requisite standard that there's likely to be a significant impediment to competition in the future seems to me even harder if this case stands. Do you accept that view?
I think it is already very hard today, and probably, again, depending on where the courts will go on the notion of SIC, it may be harder afterward, even after judgment. Of course, you can also have arguments of potential competition being developed in the case of acquisition of small startups, which would then perhaps bring you in the potential competition strand of the case law, which is equally challenging to demonstrate before the court. But it is true. I mean, I think the debate on killer acquisition, digital mergers, pharma has two elements: the jurisdictional one, which we're going to discuss maybe in a second, and then even if you get to see the cases, do you actually have the tools to do something about it, or do you really have to start looking into what the US seem to start looking into? If you look at the consultation launch last week on the review of the merger guidelines there, on notion of going towards presumptions or reducing the burden of proof. I mean, do you really have to go down that road in order to be able to, or do you want to go down the road if you want to be able to challenge transactions such as the one you were referring to? And that's something to be, we think at this stage that we can intervene when we need to, but I'm aware that many other people think we don't.
Well, that's a timely introduction to the question of the jurisdictional scope of the merger regulation. And as you know well, there have been debates over the years as to whether the two pillars of the jurisdictional test, namely that there be a concentration and therefore acquisitions of non-controlling minority shareholdings weren't included, and that jurisdiction be established by reference to revenue-based tests, whether those two principles should be revisited. And as we heard in the first session how the Commission had decided not to expand the scope of the merger regulation to non-controlling minority shareholdings, leaving the possibility for some member states to investigate them, but not having the power itself. The debate in the last few years has focused in particular, as I've just said, on the digital and pharma sector, and the impression or the view that some had that acquisitions of nascent competitors with small or negligible revenues in the EU were escaping review. You decided not to lower the thresholds, but to introduce, some might say with not much warning, a clarification or confirmation or change, depending on how you view this, and I have my own views on this, of your policy to allow or encourage member states to refer up to Brussels transactions that might otherwise escape review. Can you share with the students your thinking about that, and whether you think this represents the best way to go about capturing these kinds of deals?
Yeah. Now, look, we thought long and hard about how best to try to capture the transaction that you referred to. First, we tried to see which transaction we actually missed. We haven't seen that many. I mean, of course, there have been many people talking about these hundreds and hundreds of acquisitions by the GAFAMs in the last few years. How many of those would have been problematic in Europe? Question mark. How many of those we would have wanted to look at? Question mark as well. But still, I mean, I think there may be a gap. We thought about different options along the lines you were mentioning, Nick. Do we have to change the merger regulation, introduce a transaction value test with some sort of local nexus, a bit what the Germans and the Austrians have done? Do we have to lower the thresholds? Do we want to introduce a voluntary notification? Do we want to introduce the power for the Commission to go after close mergers like the US agencies have? So we thought about all that. And then on the one hand, we couldn't really find the silver bullet that actually would have gotten us the cases we wanted to look at, and not more than that, or at least maybe little more than that, but not a lot more than that, and would enough then impose also a big burden on businesses having to notify useless transactions to us. That was point one. Point two, we also knew that any change of the threshold would have triggered a change of the merger regulation, which would have been a complicated process in itself. It's requiring unanimity in council. So we went for the Article 22 route, which has caused some emotions in the community out there, or some concerns that we would basically create a lot of uncertainty about the type of transactions that are reportable or not. And we understand that. We're trying to pass the message, and we try to be even clearer depending on how the Lumina case goes before the courts, as to what type of cases it would take, in what circumstances, what type of consultation process would set up to ensure that we minimize the disruption in it. And we're also trying to see in parallel whether there are good cases out there that could come to us through this referral process, and try to make it maybe a less, a more, if you want, manageable way to look at cases than perhaps what you could look on paper. But again, I think the suitability of our Article 22 policy is currently challenged before the court. We think a judgment will come rather soon, because the hearing took place just before Christmas, and it is an expedited process. So hopefully it will come quite soon. So we all know, we'll have a bit more certainty, hopefully, after that on where we stand on the law. And then depending on where judgment goes, we'll have to either try to think about other ways to do things, or set up a process which hopefully becomes more and more standardized and business friendly as to the type of cases that may or may not be referred to as under Article 22.
Thanks, Michele. I mean, it seems to me that a lot of the debate has been slightly overblown, in that you had this possibility already, and it was the original intention of Article 22, was to allow for this sort of transaction to be referred if need be. Although, of course, since then, all member states, bar Luxembourg, have adopted their own rules, and therefore, I suppose one could read into the practice a view that transactions that didn't meet national thresholds weren't referred. But you've accepted referrals in those cases over the years. It's slightly procedurally messy, though, for you, isn't it? In a situation where a transaction has already closed, and you subsequently get seized of jurisdiction, because you don't have clear powers, do you, under the implementing regulation to to deal with that, do you?
No, and I think we of course would not exclude to look at closed mergers. We would like to prefer to look at mergers that are not yet closed, not yet closed, even under Article 22. But it's true. I mean, it is an imperfect tool to address the problem. We think is one which we have to test now, whether first it's legally correct and then whether it works. I don't think there's another short-term solution in the pipelines for the safe to address it. So let's see. I think the other thing which also gives us some comfort that we have not done something entirely stupid is that if you look at the effectiveness of the German and Austrian laws to date in catching these big transactions based on transaction value hasn't been so big. In order to try to get the Facebook customer, they had to dig quite deep. So look, we have to see. I think there's no perfect way to solve it. I think it's a bit of a process of trial and error by different agencies, and we'll see how our trial goes.
Right. And look, the fact that almost a year on since you announced the policy, only one reference, I think only one has been made. Obviously, it's a very high profile one. Yeah. And that could be because some member states have said they don't like the change in the law, but it could also be that there just aren't as many of these deals sort of out there that are falling under the radar.
Yeah, and there's also been a number of informal consultations with NCAs about potential referrals, which in the end we decided we were not good candidates. So I think there's also that informal process ongoing behind the scenes.
Okay, so I have a couple more questions, but I'm going to turn to Chris now, who's going to ask some questions about substantive appraisal.
Sure, I'm gonna shift gears a little bit for my first question and ask about environmental and sustainability considerations. So, Michele, obviously one of the big policy objectives of the Commission is to become the first climate neutral content. The European Green Deal gives a roadmap toward achieving that. Last year, the European Parliament passed a resolution advising the Commission to include social and environmental costs of mergers in its interpretation of significant impediment to effective competition, meaning to look not only at prices, output, and innovation, but also those wider considerations. And the Commission has been consulting on and thinking about those issues. I think now you've invited comments on how merger enforcement could better contribute to protecting the environment and the sustainability objectives of the Green Deal, which seems to signal a policy shift since some statements the Commission made 5 or so years ago when DG Comp seemed inclined to leave these other issues to different directorates or to the national authorities. So I'm just curious, what's the current thinking in DG Comp on this, and how do you envision things evolving over the next few years?
So there's no change of policy. I think what we've done in the course of last year and perhaps even before is consult ahead of a conference which took place also last year on how competition policy can help, as you say, achieving the Green Deal result, the Green Deal objectives by looking at mergers, antitrust, and state aid. I think we, at the conference, we published a policy brief in September last year, where essentially we took the view for quite consistent with what we've been saying for some time, that it is mainly for regulation to achieve environmental objectives. The Commission has a subcontracting role, it can help, so competition policy has a subcontracting role, it can help, but is not for antitrust, merger or state aid to replace regulation. At the same time, competition policy has a role to play. It has a role to play within the meaning, the concepts, and the case law of competition policy. State aid perhaps can go a bit further. We've published, the Commission has endorsed just before the Christmas break our new guidelines on climate, environment, and energy, where essentially we have a much more open approach that we had in the past to state subsidies to green projects. So state aid but look, if you look at the state aid side of things, we've been more open and in the past in having public money with a number of safeguards supporting decarbonization projects, so projects aimed at reducing CO2 emissions. If you look at antitrust, essentially what we said, and antitrust and mergers essentially are the same conceptual approach to efficiencies, that sustainability gains have to be efficiencies in economic terms, have to be efficiency within the meaning of Article 113 and within the meaning of merger control and the horizontal merger guidelines. We are not going to accept, at least that's what we said in the public, in the policy brief, out of market efficiencies, offsetting in-market efficiencies, even if these are green out of market efficiencies. We will still require pass on full compensation of the harm to the customers in the market. And of course, if there are also spillover outside the market, the better, but there has to be a benefit for consumers affected by the possible anti-competitive agreement or merger, which purely offset those. Of course, we can be open to look at how to quantify them. We can be open to look at qualitative efficiencies. We can be open to look at to have give guidance to companies more in antitrust context who want to enter into agreements and maybe fearing that these agreements breach Article 101. We're happy to do that, but we're not opening the door to a green efficiency claims outside the realm of known antitrust concepts, not least because what's next after green? If you start doing that for every commission policy objective that one commission can set to itself, then you risk opening the door to many other policies other than green that you may not want to do.
Understand the floodgates argument. I guess there are those who would argue that the environmental challenges that the world faces are a unique consideration, and it's not necessarily the case that every other social policy interest follows if the Commission were to expand its horizons.
You're right.
Into that
You're
area.
right, but you'd be surprised how many people think they are unique or their interests are unique.
If I could ask a related question, but shift gears a little bit. I mean, there are those who would argue that the Commission's perspective in not considering out-of-market efficiencies in particular, as you mentioned, is maybe a little bit narrow. A similar concern, maybe from different constituencies, has been around the Commission's view on creating European champions and viewing transactions in the bigger political picture. The Siemens-Alstom prohibition, of course, was seen in some national capitals as a failure by the Commission really to look at the big picture, that the Commission should allow the creation of European champions in a competitive global economy. There are other decisions previously, Deutsche Börse, NYSE Euronext, for example, which we mentioned briefly earlier, that could be seen in a similar light. Siemens-Alstom provoked some political backlash from a few countries, particularly France and Germany. They published a manifesto that was aimed to make EU industry fit for global competition, mainly by injecting political oversight into EU merger control and in support of creating European champions. A lot of commentators, myself and Nick included, thought that this would represent a big step backward from the great successes that have been achieved by the merger regulation over 30 years. And also not all the member states agreed with France and Germany's position. Still, though, their voices are obviously louder in a post-Brexit EU. And I think there have been some other signs that political considerations might be coming more into play in DG Comp's thinking. Example on digital strategy, maybe on controlling the impact of third country subsidies. So just interested to hear your views about the independence of the Commission of DG Comp and really the role of politics in that decision making. What's the climate today?
I think there are many different points that you made in your question remarks. I think the debate on champions and merger control has been, as you say, very much present post Siemens Alstom for some time, including perhaps the beginning of this commission. Most recently, but maybe just not seeing that it's perhaps a bit calmed down on the merger front. There hasn't been recently calls to review merger control. The focus is really much more on state aid and public support to do different things than perhaps mergers. But again, doesn't mean it's not going to come. This is a cyclical thing, and certainly the stakeholders and the member states who want the change there are still very much up in arms. There's also a more silent number of member states who really don't like this idea of champions, and they wrote to us several letters and non-papers around the time. They are the smaller ones, they are the less vocal ones, but still, if you go to counting council for a possible change in merger control, you have to probably think that at least a silent majority of member states is not really in favor of this Franco-German, Italo-Polish effort of changing a bit the merger regulation and introducing a political oversight of some sort of like resilience / European sovereignty interest into the picture. What is the political situation? The situation is one where competition policy is perhaps not as popular as it used to be. I mean, there are a number of calls in capitals, but also in the Commission, for more protectionism in many different ways, be it sovereignty, being autonomy, being repatriation, reshoring. I mean, the words can be different. Still, so far at least, while the Commission may become a bit more political and a bit more sensitive to capitals than it used to be, it has not trickled down to us as competition policy for now. You never know. I mean, it can change, but so far I think we've been able to do our things as they should be done. But it's true that, I mean, in the broader political debate in Europe, the exit of the UK, the shift by some countries like Netherlands and others towards a less, and even the Nordics, towards a less open market, free trade approach, has also some repercussions on the way people look at competition. That's clear.
Thank you. Nick, anything else, or I guess we can also open the floor to questions.
No, I guess I well, just to pick up on those themes, I had a question. For a long time, Michele, the Commission was seen as being perhaps the toughest enforcer in the world, certainly tougher than its US counterparts, and some of the Commission decisions were criticized, as you recall, by some US agency heads, GE, Honeywell in particular. And then there came a period where we in the community got quite worried about China and the use of merger control in China, sometimes to achieve what was perceived to be political or industrial objectives. But the debate over the last few years has also crystallized a slightly contrary view, namely that the US agencies were too permissive, but perhaps even the European Commission was too permissive. And some of the noises coming out of London and Berlin and perhaps Australia as well, they seem to have formed themselves into an alliance of the Ayatollahs in merger control, have at times suggested that maybe the Commission hasn't been strict enough, and 30 prohibition decisions over 30 years. I know it's 31 now, but it's not that many. I mean, the UK in the last few years has, I don't know exactly the numbers, but prohibited about 15 deals or something like that just since Brexit. And I know you say sometimes in response, I mean, you institutionally, yes, but think of all the remedy cases and think of all the deals that didn't happen or that were abandoned. But do you think that we're likely to see any change in enforcement practice? I mean, we've obviously seen, as I said, I will stop my question in a second. We've seen in the UK the ability of an agency applying exactly the same rules as it's historically applied to tighten up enforcement and to block deals that would previously have been approved. Do you think we as students of the Commission's application of the merger regulation should expect more vigorous enforcement in the coming years?
I don't want to see this as a race between authorities to be the toughest. I don't think it's a healthy way to look at things. We are trying to do what we think is best. Of course, trying to work with other agencies and try to achieve consensus when possible on cases. Sometimes it's possible, sometimes it's not. I give it to the CMA that they've been very, very active in the last few years, on merger control in particular, on the rest maybe a bit less, but I mean, merger control quite active on in enforcing, and they really are position themselves as the real new big enforcer out there. The other agencies, the Australians, the Germans, the US so far, let's see, they still have to do it. I mean, so we have to see. But I think we don't want to be drawn into a race as to who is the toughest competition enforcer out there. We want to try to work with people and to try to achieve, to do what we think is best. We don't feel we're under enforcing. I think a discussion to be had, we're having it before with Chris and the students, is around remedies, in particular behaviorals, whether for and digital, whether in the digital world you really have to, can you really have effective behavioral remedies, or you, in the absence of a proper solution which is structural, you have to go for a prohibition and not accept those. And that's discussion which will be probably very much live also with the US agencies going forward. But look, these are new dynamics with Brexit, CMA getting closer to the US and try to be coalition build with other agencies out there. It's an interesting dynamic to be seen. Probably a more challenging one for emerging parties going forward, I'm afraid.
Thanks, Michele. Sorry, Chris, you were opening up the floor, which is a great idea. I don't know if any of the students have questions.
I have a question in relation to the Microsoft Blizzard merger we mentioned earlier already. So like essentially a part of the merger is going to be the metaverse. How do you see market definition for that? Is it just like you're going to go out there and ask all the companies, what do you think the metaverse is? And then you come up with your own thing, because essentially no one really knows what it's supposed to be, who will own it, who will dominate it. And the second part, if you were going to construct it, would you see it as just another gaming market like PC, console, mobile, or is it more like this overarching construct that unites several markets?
Look, I have no answer to your question. The best answer would be we can leave the market definition open, so we don't have to take a view. No, actually, I don't know. It is very hard. Metaverse is something which my boss has been talking about publicly quite a bit in the last couple of days, because she seems to be quite interested into it. I don't know. I really don't know. It's we hope to understand it at least, but it's really just started a couple of days ago. So I don't know. I think these are the metaverse questions go beyond the Blizzard acquisition. Go as to, it's going to be a market where you're going to have a replication of the offline world online. How do you apply, what rules apply to the metaverse world when you go shopping in a metaverse, when your things in the metaverse, how that world is going to be regulated? I think is a whole new chapter to be discussed for many years, I think.
So do you think even a phase 2 investigation would be enough time to understand that all?
if we stop the clock for 10 years, maybe we can get to that. I don't know. We have to be, has to be at least enough time to look at the merger, probably not to understand the metaverse as such.
I think they've agreed that the process may go on for as long as 18 months. So they obviously anticipate a careful review, or at least to take an insurance there might be one. Any other questions?
Professor,
yeah.
Yeah, Professor, I have a question, maybe a stupid question. I'd like to know why the safe harbor is not available in merger control. Because when we learn the horizontal guideline and vertical guideline, they have safe harbor. They can give some legal certainty. But why no safe harbor available here? Thank you.
Well, it's a good question. I think our safe harbor is a simplified process that Chris described during the one of the previous sessions. No, because if a merger meets the thresholds for being notifiable, it has to be notified. You have to do it. Sorry, it happens. The law says that. But it also tells you that if your market shares are below 20% in horizontal and 30% in vertical, you can have a very quick review. Not provide many information, short notification, simplified form, and a clearance of often within even before 25 working days. So you still have to notify, but you have to provide much less information that you would have to if your market share were to be above the safe harbor threshold, if you want.
While others are thinking of questions, in the first session, we got a question, Michele, on how to work. Oh, I'm sorry, Jan, you've got a question. Go ahead. You have to unmute yourself. Sorry. Yeah.
Unmute. Still.
Try now.
Yeah.
Maybe type your question while I ask another one, which is in the first session, Michele, we had some discussion on use of different types of evidence. And I talked about how market shares have always been relied upon. And over time, the Commission has expanded the kind of information and data it looks at, including in particular to look at internal documents and so forth. There was a question about how useful economics is. And by economics, I mean quantitative empirical work. What's your view on that?
I think it is useful. I've not seen recently a case which has been decided purely on economics. But the chief economist team in COMP still has an important say in cases. It can support case teams to build a theory of harm or to rebut complaints. So I think it's a useful addition to the arsenal of arguments that the parties would have together with market shares, internal documents, and factual evidence. Perhaps it's a bit less key than it was a few years ago. It's my impression, but if you want, you cannot do without. No, it's still one box to tick and something that you have to do. And at the margin, it may have help the parties another voice for them or against them in the internal debate also within the Commission as to what to do on a case, because of course the chief economist is always involved, and of course he has still a respected voice in the debate, and so if he or his team are persuaded of the party's argument, of course it helps in the discussion, but perhaps it's not as hype as it used to be some time ago, is my view.
Yeah, that's my perception too, I think. Jan, how you do typing your question? Are you there yet?
I haven't seen it. Where is it?
Oh, he's almost there. Anyone else got a question while we're waiting for Jan? Let me ask a question about internal documents, Michele. You're now gathering hundreds of thousands, sometimes millions of internal documents, and you run checks on them with forensic tools and so forth. What's the internal check on the officials who are investigating to ensure that they're making a balanced and fair review of the documents? Clearly, searches have the ability potentially to turn up unhelpful documents, but those may, of course, be counterbalanced, sometimes outweighed by exculpatory documents that may not be within the search terms or may not be so easily found. How do you, as an institutional matter, ensure that the review of the documents is fair?
I think that the check and balance comes from the discussion with the parties. I think I don't think there's an institutionalized way to make sure that teams dig out both exculpatory and inculpatory documents. We rely on the teams to do their job as they should be doing as officials who should try to do an objective assessment of a case. But of course, the case team also tries to build its own case and try to find potentially documents building on a theory arm. I think that the real check and balance comes in with the party submission, which already now knowing the game, already before the SO process starts feeding the commission with submissions on with also internal documents on supporting their arguments, and then of course when the like full-fledged dialectic between the parties and the commission starts in the post-SO process. But there's no such thing as a institutionalized system to ensure the impartiality of the review of the document.
Okay.
I'm now reading Jan's question.
Jan's question is about efficiencies and environmental considerations.
You're probably right. It really depends what you mean by environmental efficiencies. There can be different ways to go about it. Can also be using more sustainable products. Can be using a less polluting production process. But it's true that in the end they have to be linked to economic value, which accrues to the customers in the relevant market. So let's see. The real problem we have is that we have no case. Is that as much as we've been asking for, this is more on the antitrust side of things than on the merger side of things, but we've been asking now for years to parties to come forward and tell us what agreement you want to do and you feel you cannot do because competition stands in the way. So we can try to help you to do it. Come on a confidential basis. We're not going to go after you if you tell us something you want to do which is not good. We just come to us, try to give you guidance. We really want to do it, but we haven't been able. Now last week, I think the Germans came out with 2 guidance letters on environmental agreements. The Dutch have been looking into that for some time. They're more on the pro-green efficiency spectrum of the debate in the ECN. But even them, they've been struggling to try to find good cases to actually give guidance to. But it's interesting because now it's picking up. The Germans, who used to be on the opposite side from the Dutch, more on the conservative economic efficiency side of things, they came out just last week with 2 guidance letters. So I think hopefully we'll pick up a bit also to give some confidence to the parties to come forward and ask for guidance. So we can also try to understand a bit better agreements which are not pure greenwashing, but are proper environmental agreements that we can try to help.
Okay, I think we're almost at the end of time. I did have a question, Michele, for the students. If they're interested in pursuing a career in this area of the law, what should they focus on? What sort of skills are useful in this area? How to be successful in the field?
You know this better than me. You and Chris know much better than I can answer that question. But I think, in my view, that whether the interest leans more the public sector or more towards the private sector, I think a private sector experience is still very important. Even if, talking about more from the commission side of things, from our side, having colleagues who have been exposed to the private sector, to the world of law firms or consultancies or economic, whatever type of private sector one is talking about, companies in-house, actually helps to bring some sort of reality check as to what we do and more of a business sense and be more of a perhaps ability to understand the real world as opposed to somebody who basically has been only in the commission. So I think whatever career perspective, having a mix of both public and private sector is a good idea. But that's again my own view.
Thanks very much. Well, I'll leave Chris to have the last word as he's in the chair in the room. And just to remind everyone that whoever gets the highest score in their paper gets a copy of Chris and my book on the merger regulation.
And that will have nothing whatever to do with your reviews of the course and how I rate as compared to Nick. No, thanks to everyone, and thanks especially to Michele for spending the afternoon with us. It's been really interesting to hear your perspectives, and unusual to get this kind of access to such a senior official to hear his very candid views on a lot of the main issues that we work with every day. So thanks very much, Michele.
Well, thank you for having me.
Thanks, everyone.
Yes.
Hope this has inspired
Thank you. Thank you. Oh, yes. Thank you for joining all. And I see you all next week on Friday for the next session. Thank you very much for coming. And Nick, Michele, and Chris, it was a real honor to have you today and to have this final Q&A session. Thank you all for your time and wishing you to see you next year. Thank you.
Bye.
Thank you.
Bye.
Bye.
Everyone,
Bye.
stay well. Bye.
Have a nice weekend.